Your Lordship, sorry.
My Lord, the departmental proceeding initiated, Your Lordship. To departmental proceeding. Tomorrow is the date fixed.
When it was served, notice was given to you.
Notice given 2 months before.
There is no urgency. Yes.
I prayed for some time, Your Lordship.
Directed to after 2 weeks. Any day next week.
What
Eviction matter, my lords.
Eviction.
My lords, rate appeal.
You are
From the shop room to appellants were evicted, my lords.
evicted already.
Yes,
Week after next.
Pardon to make a mention, Your Lordship. 2024 matter, Lordship. Computation of contractual period towards length of service. A limited issue. That's
Item number
2018 matter, my Lord. Tribunal order is under challenge. 1 week after next thing.
Administrative tribunal.
My Lord, so tribunal order is under
Which
challenge.
tribunal?
Cat managers.
My Lord, 24 matter, pension matter.
Pension matter.
My Lord,
Next week.
contempt, then reachable.
2022 matter had to be admitted, my lord. Service matter, my lord.
Respect. Not come for admission also.
It is 20 times it is listed. It is yet to be admitted, my lord.
Next week.
22 matter, my lord, against the CAT, my lord.
Against CAT.
Yes,
Week after.
2017 matter. Admission matter.
Next week.
contempt arising out of a writ appeal, Your Lordship. There was contempt arising out of a writ appeal.
Writ appeal.
Your Lordship.
Next week.
Item number 9 may kindly permitted to withdraw the case.
Item 9. You find a memo at least. Give paper to madam.
Please, Your Lordship, item 20.
item 9. I am both the response. Both the response.
You are for respondent. Do you have objection from counsel for the petition? It's a petition or appeal?
Appeal. Rate appeal.
Counsel for the.
Already there is a noting memo is there.
You have filed a memo. Counsel for the appellant has filed a memo dated so and so, seeking leave of the court to withdraw the appeal. First memo reads as that. Next paragraph. Learned counsel appearing for the contesting respondent number 1 submits that he has no objection for granting the leave to withdraw. First. Next paragraph. In the above circumstances, appeal is disposed of in terms of memo.
Please, Your Lordship, item 20. I am for respondent number 1.
20.
Lordship is seeking a time for instructions from a client as per the last order.
Yeah, which year matter, brother? 24 matter. You wait, that advocate may be waiting in the court hall. Na? Have you informed the other side?
Lordship, state is the
State is the appellant. Brother Behura. Mr. Behura.
My Lord.
We have objection for the adjournment. 24. Follow up 2 weeks with the request of the counsel appealing for response number 1.
My Lord, item 22, my Lord. Item 22, I am appearing for respondent number 6, my Lord.
22.
My Lord. On behalf of my Lord, learned senior advocate Mr. Mahabhadra is suffering from eye infection, my Lord. I have informed my learned senior, my Lord, Mr. Das, my Lord, to maybe taken up any that it.
You are for appellant?
No. I am the respondent number 6.
Or 6.
I am.
Mr. Das, can you grant?
Yes.
Yes. Call this matter after 2 weeks at the request of counsel in the ground of ill health of arguing counsel. Counsel or 6 on the ground of ill health of arguing counsel. Okay. Yes. Start.
Item 1.
May I please, Your Lordship?
Yes.
Item 1, Your Lordships. I am the lead counsel for the other side. I have a very bad throat infection today. I'm actually not able to speak, Your Lordships. If that can come next week, Your Lordship. Next week, Your Lordship.
Next week at the request of the senior advocate, Madam appearing for answering responses.
Your Lordship's kind permission.
Yeah.
In this case, in fact, another court bench, no judicial order has been passed, but the state was directed not to take any action till at least. Yes.
To the judgment. They have also issued a letter to that effect.
Anyway, next week we'll look into
That's
that.
it.
Yes.
Next. Item 2. Yes.
So now, as a court is writ appeal against the order of honorable single judgment.
Yes.
The very issue has already been decided by the division bench. Very issue in writ appeal in same issue.
Covered by judgment.
My lords, he claims right title, declaration of right title interestment.
Yeah, competent. Decided similar.
That's what. How can we,
Not similar he
well, how can we decide
My lord.
whether there is adverse possession or not? It's a matter of question of fact.
Well, fact remain like this, man. In the Euler Act, man, this is a case in the Euler Act, man. In the Euler Act, there is a provision under section 8(4)(a), and the person who is in possession since more than 30 years. There was also encroachment case in the year 1982-83.
How can we decide? It may be.
Well,
That single judge has said, go before the civil court. That's
no. Court say go to the appellate authority. Appeal is there.
Go to
Against the order of a Tahsildar, appeal lie to sub-collector under section.
all right, to the statute. So that
In that view, this court has directed you go for appeal because civil court has no jurisdiction to entertain the Euler application. Euler dispute, civil court has barred jurisdiction.
jurisdiction is barred.
You have gone in Euler.
Euler, there is a bar for civil court.
For civil court.
Civil court. That's why this court has directed go for appeal because it is a statutory right available to you against the order of the Tahsildar. So if Tahsildar has passed any order, it is appealable.
Appealable.
Well, as per section 58.
You have to stop after saying one sentence. You are not reading a novel. You are making a submission. We have to treat it.
Well,
Is it? So your contention is it's an appealable order.
well,
You want to go in appeal.
well.
All right, we'll permit him. Wherever you want to go, you go. We will not say this, that, this hospital, that clinic, that kind of question. It will not say. We will say you have said that you have alternate remedy and you will explore it.
And the similar view is taken by this bench, my lord. Bench has already said like this. Appeal is there, fundamental right.
Where is the law decided? Where is the law decided in this? We have got great respect for the coordinate bench is another thing. But when it does not declare law, we have to declare that it does not declare law. Learned right now. This intra-court appeal seeks to lay challenge to a learned single judge's order dated 18/7/2025, whereby WP number so and so has been calling in question the order of Tahsildar made under the provisions of section 4(1) of Orissa Land Reforms Act 1960 has been negatived. First, next paragraph. Learned counsel appearing for the appellant submits, and he places on record a copy of the decision of another coordinate bench in writ appeal number 2979 of 2024 between Dilip Kumar Pradhan versus State of Odisha, disposed of on 4/3/2025, that against the order of the Tahsildar, a statutory appeal is provided under section
58.
58
Well,
58 of the Act, and therefore appeal be disposed of, granting liberty to approach the appellate forum. First one. Learned next one. AGA appearing for the all OPs very fairly submits that whatever alternative remedy the appellant wants to pursue, he may do it, and therefore appeal be accordingly disposed of. First, next paragraph. In view of the above, appeal is disposed of, reserving liberty to the appellant to avail the statutory remedy in accordance with law. First off, whatever time spent in the prosecution of this appeal shall be discounted while computing the period of limitation prescribed for such appeal. First, registry to return the impugned order of retaining a photostat copy thereof in the file. Okay. Next, item 3.
May I
Nothing
please?
is decided. No?
My lord, item 3, I pray next week along with a DWA number 44895 of 2025.
Call along with.
My lord, both the appeals are arising out of a common order.
Yes.
Obliged, my lord.
At the request of the counsel appearing for the appellate. Next. Item 4.
May I please, Lordship?
Yes.
Your Lordship, again, once again, Lordship, contrary to judgment. Section 24(2)(c), Lordship, that larger bench judgment, your Lordship delivered that. The mandatory requirement is the compliance of 24(2)(c), Lordship.
24(2)(c) Education Act.
No, Lordship, the Orissa Gram Panchayat Act 1964.
Panchayat. Okay. These, that it did not
They have not
connect
complied.
with
They have not complied, Lordship, 24(2)(c). And Honorable Singh has, Lordship, perhaps the Lordship has gone through one step ahead and he has dealt with 24(2)(e), which Lordship which is consequential of 24(2)(d), Lordship. But by interpreting that 24(2)(e) is there, then no requisition is required. If only formal notices suffice. If you have knowledge, then suffice, Lordship.
No, that may not be correct.
Cannot be,
Your
Lordship.
Lordship may see the paragraph 4, Your Lordship, of the judgment, Your Lordship, page 49.
Page number
49 of the brief, Your Lordship.
49.
Yes, sir.
Go to 49.
Running page number 49, Your Lordship.
According to
Page 3 of the judgment, Your Lordship. Contention that is not from the writ petition, Your Lordship. There, Your Lordship, it has been stated that the last 2 lines, Your Lordship.
Just a second, we are reading.
Yes, yes, Your Lordship.
Served on the petition to the conveyed to you on 29 January 2025. No, along with that notice, they have to.
Yes,
they have
Your
to
Lordship,
accompany.
that was served, Your Lordship, by the PAO
Served on which date?
on 29 January 2025, Your Lordship.
Who served notice
The PO,
of
Panchayat Executive Officer, Your Lordship, on the petitioner.
no notice of no confidence motion was served.
Yes, Your
By
Lordship.
whom?
By the Panchayat Executive Officer on 29th, Your Lordship.
How Panchayat?
Ultimately, the resolution and requisition were served
Served by whom?
on the petitioner through the concerned Panchayat Executive Officer
Which section reads how?
and with the notice also it has gone, Your Lordship.
Where is that?
It has gone, Your Lordship, because all other ward members, it is the last, Your Lordship.
Where is the finding to that effect?
Here, Your Lordship, at para 10, Your Lordship. Your Lordship, para 8. 8. There it has been stated, it is pleaded therein, page 52. It is pleaded therein that service of notice through the concerned PO is admitted by opposite party number 2 to 4. As regards the proof of service of notice received by the petitioner, it is pleaded by the petitioner that the same has been managed after completion of note certificate motion, Your Lordship. That the petitioner is claiming. But the Panchayat Executive Officer has served the notice with a copy of the resolution and the requisition on the petitioner. And also it has gone by post on 31st January 2025, Your Lordship. And the postal receipt had also been marked as annexure D/2 in the counter affidavit they have given, Your Lordship. It has also gone by post, Your Lordship. His contention is that on the date of posting and the date of the meeting held, there is no 15 days gap, Your Lordship.
Yeah.
But the note it has to be construed that on the date the date was fixed. The notice was issued and the date was fixed. There should be a clear gap of 15 days, Your Lordship.
15 days.
Yes, Your Lordship.
But that period is shortened now.
No, Your Lordship, that is not shortened, Your
When
Lordship.
it was served, how notices should be sent under the Act? Is it by Muddam?
By certified posting, Your Lordship.
Certificate of posting. What is
Posting.
that?
Posting, Your Lordship.
Which section says?
Section 24,
In fact, Lordship, there are two provisions.
We are asking you.
No provision in that, Lordship. How to serve, Lordship? There is
How
no.
to serve with
There is no. They have not come up with rules, Lordship.
rules, Your
The
Lordship.
statutes say there must be rules. There is no rule, Lordship. They have not prescribed rules.
Only D says that the aforesaid notice shall be sent by post under certificate of posting.
Post is there.
Lordship, I am
Yes.
clarifying, Lordship.
And a copy thereof shall be published at least 7 days prior to the date fixed for the meeting in the notice board of the Samiti. The full bench judgment also says that notice of 7 days. There should be a notice of 7 days. That has also been done. And the notice resolution copy and the requisition copy has been served on the petitioner,
It
Your
was
Lordship.
sent by post by certificate of posting.
Yes, Your Lordship. On
Where is the
31st.
record? Show me. Show
Record,
us.
Your Lordship, para 4, Your Lordship, para 4, page 50, Your Lordship. The single bench has taken into account, single bench judge, Your Lordship. They have stated that the last line thereafter, and ultimately the resolution requisition was served on the petitioner through the consent PO on 29 January 2025. And in support of such claim, annexure C by 2 is referred to. It is pleaded that the notice dated 27 January 2025, along with requisition copy besides the resolution, had been sent by post in the address of the petitioner on 31st January 2025.
All right. So
And in proof of the same,
1 second, sister. You have to send notice along with copy of
requisition and resolution.
requisition and resolution. Show your certificate of posting.
Your Lordship, it is being in the records.
You
The records may be-
call it 2:30.
Yeah.
All right. Possible. Item 5. That's the only point.
Pardon, my lord, I am on VC, my lord.
Yes, sir.
The present petitioner is the auction purchaser in a auction conducted by the authority officer under Surface Act, my lord.
Ah.
The auction, after a participation in the auction, petitioner has paid the 25% bid amount.
Yes.
Thereafter, he found that there is serious defect in the title of the property and which has been concealed by the bank. Therefore, he made an application for refund of that money for not to proceed with that auction. That has not been dealt with. He filed application, surface application before the DRT Cuttack, which registered as SC number 52 of 2025. Still then that the hearing has not been commenced and the 70 lakhs has been withheld by the bank.
We'll direct them to hear and dispose of your matter. No? Which is that, what is that case?
Prayer, essay number 52 of 2022. My lord, in prayer portion I have written.
52 of 2022. Krishna, who had participated in an e-auction undertaken under the provisions of the Surface Act 2002, is complaining against long pendency of his essay number 52 of 2025 on the file of DRT Cuttack. First, counsel submits that right to speedy justice being a facet of the Constitution of India, Article 21 of Constitution of India, under a curtain of decisions of the apex court, pendency would not augur well to the meaningful exercise of such a right. First, there is force in this submission. Next, notice to others is dispensed with, since we are not passing any order on the merits of the essay, and that we are only directing the jurisdictional DRT to hear and dispose of the same on merits after giving opportunity of hearing to the stakeholders. First, next one, in the above circumstances, this petition is disposed of, requesting the learned presiding officer of the DRT Cuttack to hear and dispose of petitioner's essay number 52 of 2025 in accordance with law, keeping in view the observations herein above made within an outer limit of 3 months. Preferably within an outer limit of 3 months. Okay. All content. The registry to send a copy of this order to the OPs by speed post immediately. First, since this order is made ex parte, it is open to the OPs to seek its recall if grounds do exist there.
Problem.
Item 6.
May it please, my lords.
Yes.
The application, my lords, challenging the order of the learned tribunal, Central Administrative Tribunal, my lords. Page starts at page.
Say disciplinary inquiry. Yes.
My contention before the tribunal and also before your lordship is this, my lord, the entire proceeding is without any jurisdiction, with no authority.
Why?
My lords. The All India, my lords, aims regulations, your lordship finds that regulation at page 169.
Next 15.
My lords, 169 relevant pages, this, my lords, 170, 180, 186 and 187. Now at page 186, your lordship will find the petitioner, my lords, was the head of the department, pediatric surgery. Incidentally, my lords, he was one of the best doctors in the country. He was earlier working in the my lord, St. John's, Bangalore.
That's all right.
My lords.
But now you are going to argue on jurisdiction.
I'm going to argue on jurisdiction.
He may be like William Osler, but that is not the point.
My lords?
He may be equivalent to William Osler, a great surgeon of Austria. Yes.
That's not the point.
Show that point.
Page 186, Group A, my lords. 2.
He is Group A.
He is Group A. 2. The governing body, my lords, the appointing authority. Appointing authority is the governing body, as your lordship finds from the third column.
Authority competent to impose penalty or penalty.
My lord. All penalties, governing body.
Just to rule 11 now.
Governing body. Now, president is only authorized for penalties 1 to 4. That is, the B, president, is only authorized for penalties 1 to 4. That is minor penalties. Now, my lordship may turn to the next page. Page 187. Authorization of the director.
You have to look at us. Come to column 4.
Column 4, my lords.
At page, you are reading 186. There, yours is item number 1.
No, item number 1, sub-item 2.
It is other post.
2.
Item number 1, sub-item 2.
Other one group A is only director. Then the other post, head of the department. Group A has various posts. This is, one is director, exclusive, one is director. If it is a director of the institute, and this is the other posts.
He is not director.
No, he is not director. He is the head of HOD. HOD.
Other posts, it's a governing body.
Governing body. All penalties, governing body.
All penalty.
Governing body, which would mean major penalty also.
And there is one more column below that, na? Penalties, Roman
1 to 4. 1 to 4, your lordship may, this is a minor penalty.
But now what is the penalty?
Penalty is rule 14, major penalty charge sheet. Charge sheet is at page number 159.
What do you say, brother? How this point is treated by the tribunal?
Before that, I'll just take your lordship one page, next page, 187. 187, the stipulation. That's the mandatory stipulation in the rules, in the Act.
Authorization of the director.
Authorization of the director, All India Institute of Medical Sciences to issue charge sheet and statement of allegation, penalty and suspension orders after obtaining the approval of the governing body. The President, All India Institute of Medical Sciences, as the case may be. The notice, charge sheet and statement of allegations shall be signed by the director on and behalf of the governing body or the president, as the case may be, and the document shall also expressly state this fact. Now, signing of the charge sheet is only a clerical act. The main approval has to come from the governing body, that is the appointing authority. As my lords, the law has been laid down in P.V. Gopinath, subsequently my lords followed in Sunny Abraham's case. Now, I raised this point. Before that, my lords, I'll take your lordship to page the
governing body which the proceedings, where your lordship will get a clear idea as to how they have proceeded. Your lordship comes to page 154.
154.
154. Agenda item 8 by 12. This governing body was held on, meeting was held on 148 page, my lords, 22/11/2021. 22nd November 2021. The agenda item 8 of 2012. The 12th, 8th of 12th governing body. Initiation of disciplinary proceedings under Rule 14 of the CCS rules against Dr. So-and-so, professor in the Department of Pediatric Science, based on the report of the FFC as accepted by the GB and his replies to the show cause. Now, my lords, the first para, sub-para, last line. The GB has authorized to initiate disciplinary action, issue charge sheet as per the provisions of the CCS rules with prior approval of the President if replies of Kanishka Das to the show cause notice were found to be not satisfactory. Then next paragraph. Show cause notice has been issued to Dr. Das, so-and-so, show cause as to why discipline.
Sir, kindly do not use name of.
I'm not. That's why I'm glossing over
his reputation.
I'm sorry. I'm just glossing over that part. To Dr. So-and-so and so-and-so. Then the second line. The replies as received from so-and-so has been examined by the director and found that the ground taken by so-and-so in his replies to the show cause denying the reports of the FFC are not factually correct and found not satisfactory. It was proposed to issue charge sheet under Rule 14 of the rules, and the same was placed before the President. The President has asked the director to place the same before the next GB for a decision. Now, next GB was not convened and the charge memo was issued. Immediately after this, the charge memo has been issued.
The point is treated by the tribunal.
Tribunal treats it, completely glosses over the point. Your lordship will see page 50. Tribunal merely matters paragraph 14. It is seen from schedule 2 that the governing body is the competent authority to impose punishment in the disciplinary proceeding, and the point completely glossed over. The approval of the charge sheet and that aspect has been lost sight of. With the approval of the governing body, that he loses sight of. Then the one short cryptic paragraph. It is seen from Annexure A12 that the memorandum of charges are issued by the Director AIMS, Bhubaneswar, for and on behalf of the disciplinary authority by the order of the governing body AIMS, Bhubaneswar. Therefore, we find that the charge memo has been issued as per AIMS Act, dated so-and-so, notification dated 18/10/2019 on examination of the facts and grounds taken by the applicant, keeping in mind
Any other point you want to?
No,
What are the charges?
Minutes?
What are the charges?
Minutes. Charges, your lordship will see, page.
You can tell it orally.
Minutes. Charges, principal charge is that there was a tiff with another professor. There was a tiff with another professor. Principal charge is, my lord, that the delinquent failed to engage so-and-so in the activities. These are the charges. No charge of misappropriation, no charges of misconduct, no charges of...
How many years of service he has put in?
He'll be hardly another 2 years left to retire, 2.5 years left.
Any disciplinary inquiry was taken?
Nothing.
Earlier?
Nothing.
Where have you stated? His service records are spotless?
My lords, I have... there has been no...
We're asking you.
My lords.
You are only a senior advocate.
No,
You can only argue. And you can argue on record. Nothing beyond.
I'm sorry.
Whether your client is here?
No, client is here. My client is not here. Client is not here.
Yes, brother, what do you say?
Possibly.
Where is the treatment of that contention?
The Lordship, I'll take instruction in this regard.
So gradually you take instruction and come to that.
Yes, Lordship.
Good luck. No allegation will be filed. No allegation, nothing. Issue rule. First off, the senior advocate appearing for the petitioner points out that the issue of competence and jurisdiction as to who should institute the disciplinary inquiry is a matter of rule, and that rule has assigned a role to the governing body. Semicolon. The material on record does not obviate the role played by the governing body, and therefore this aspect having not been properly dealt with at the hands of the tribunal, there is a scope for interference at the hands of this court for setting the order at naught. First, matter requires deeper consideration. Next paragraph. Matter requires deeper consideration. Semicolon. We are told at the bar that the petitioner has got a short stint of service to superannuate. Semicolon. It is also told to us, by learned senior advocate appearing for the petitioner, that the service records of his client is spotless. First off, matter requires deeper consideration. First off, the rule and notice above. An application is moved seeking interim protection pendent a litigation. First off, it is supported by an affidavit. First off, as already mentioned, matter requires a deeper consideration at ease. And in the meanwhile, certainly heavens will not fall down if the disciplinary proceedings in question are interdicted, pendent, deleted. Next point, in the above circumstances, application having been favored, the disciplinary proceedings are kept at a bay until further orders. Great. Next.
Item 7.
Yes.
Challenging uninsured one, your lordship. My father was a loanee. So tomorrow is fixed for the e-auction. So I am ready to pay, your lordship, but some time we given, I pay the amount. That is the.
Have you brought the
melon
back to court? Then go home. Whatever happens, happens there.
Well, because my lord, I have paid 2,28,000. In 10 days, 7 days, I'll pay all the amount because my lord, that is a residence house. Otherwise, tomorrow will be.
It will be auctioned.
My lord, that I will pay. Your lordship directed.
Where is your money? Your words are not money.
That's right, my lord.
Therefore, bring money here now.
Today, my lord, that
then nothing.
Today, then I'll take instruction. Even I will pay tomorrow. Today,
no.
2:30, my lord.
At 2:30.
Yes, my lord.
Password. Bring money back. It will move the court. Yes.
My lord, that is prefer. 50% are directed to pay other. They have paid 9 lakh something.
We do not know all that.
My lord.
My brother is not happy with my interference all the time. Still, I am requesting him to be a bit liberal so that money comes to the bank. But that money, without money, I cannot convince my brother. Though by your argument, he can convince me. This is a bench of 2. And one judge agreeing with you is insufficient for interference.
That's
Bring money. At 2:30.
Taking to 30 man. Yes, because some amount is.
You deposit 50% now.
Yes.
Then we will ask your client. He is here nodding to see. You have to see the judge. You have to see the client.
No, he's not.
Where is the advocate?
No, he's not trying.
He's not, not your client.
No. Yes, madam. Tomorrow, 50%. Tomorrow I will deposit, madam.
Before auctioning?
Yes, madam.
Challenge is to the e-auction scheduled to be held tomorrow. That is 28 January 2026. First up. Learned counsel appearing for the petitioner borrower submits that his client is ready and willing to repay the entire loan, and therefore the auction be interdicted. First time. He also tells us that he would pay 50% of the amount in demand as on this day to the bank, which is that OP?
Okay, my lord.
Indian
Overseas.
OP number one.
One
and two. OP number one bank, which is represented by the panel counsel Shri so and so. You are after money after all. Why you want to sell the property?
No.
You get back.
He's ready to pay that pay, but he has only pays 13. He has already fixed his stop.
If he pays now,
Yes.
he will retain his property. Otherwise, property will be sold. Learned panel counsel little opposes the grant of any interim order. First. Next one, having heard learned counsel for the parties and having perused the petition papers, we are inclined to grant the application in IN under so and so, supported by affidavit. And affidavit by a little modified direction in variance with the one sought for in the application. First off, it is like this. The scheduled auction shall not be held if the petitioner pays 50% of the amount due to OP number one bank. At what time? Auction is at what time?
My lord, at 11 a.m. to 12 p.m. That is mentioned.
Before 12 of the clock, tomorrow, that is 28 January 2026. Failing which, not only interim order stands vacated, the petition, but the petition itself runs the risk of being thrown out. Okay. You inform the bank. Okay. Before 12 of the clock, he will pay. If he pays 50%, don't conduct the auction. Then you can reschedule us. Okay?
Urgent copy.
Next. Item 8. Immediately print it.
Item 8 this matter may be taken up next week.
Next week?
Because I have been disengaged from the panel.
Huh?
I have been disengaged from the OUT panel. So they may engage that new panel.
Is it?
Yes.
All right. Week after next week?
Yes, madam. It will be better.
Week after next.
And I will also instruct them to.
I am appearing for R2, my lord. My appearance, my lord.
Already admitted.
No, they're not content. It's a date pilot. Because now they are not implementing the order because of this dependence of the retapping.
No. Stay is granted. The interim order is
granted.
Yes, interim order to continue. If any is continued.
Well, by place of fixed date, pilot authorize it.
After 2 weeks, it will come. Put some date. Yes.
Item 9 has been disposed of. Item 10.
This is an appeal by the state, intra-court appeal, involving a delay of 156 days, my lord.
156 days.
156 days.
What is on merits and what is the condition for condoning delay?
On the wrong fixation of pay on the higher grade, some amount were disbursed to the respondent, which the department seeks to recover.
What is this, Rafiq Masi?
No, Rafiq Masi will not apply because Rafiq
What it is?
class 4 employee, that class 4 employee.
And class 4 also covered by Rafiq Masi.
Yes, class 4. But this is not class 4. This is not, that's the distinction. This is not class 4. This is a trained graduate teacher.
What is that?
Teacher.
Group C,
Group C.
Group C.
Group C.
Group C, class 4.
Yes, ma'am.
Group C is class 4. Group C is class 4.
Class 4.
Both are class. C and D are class. We have held that way.
Yes, ma'am.
Anyway, but the rule says that, and the undertaking given by the respondent that if any wrong.
Subject to that undertaking, it is.
Yes, we seek to as per the rules also provides us. Any disbursement which is not in accordance with law.
Will condone delay.
Yes, my lord.
Take amount on that delay.
Yes, my lord.
How many days?
156 days.
159. It is 120 rupees per day now.
Now 20.
Yes. This intra-court appeal is filed after taking a delay of 169 days.
156.
150 days. 156 days. An application accompanied by affidavit is moved in IA number so and so, seeking condonation thereof. Mr. Panda, AGA, submits that delay is short and there is an explanation offered for the same, and therefore that to be condoned. First of all, he also tells us that by condoning delay, extra merits are not added to the appeal to the disadvantage of other side. Yes. Learned counsel appearing for the respondent. One respondent?
No, my lord.
No.
Respondent number 3.
All respondents?
No, my lord. Only respondent number 3 for the private respondent. For the private respondent, my lord.
For one.
One, sorry, my lord. Private respondent.
Submits that. Application may be allowed on terms, reserving all contentions on merits of the appeal. First one. This is appreciated. Next one. In the above circumstances, application is allowed. The appellant to pay. Which appellant shall pay?
Appellant one.
Appellant number one shall pay to the respondent number 1 a sum of rupees
3,120.
3,120 within 2 weeks.
Within 2 weeks.
Failing which, this the application shall be deemed to have been rejected.
Yes.
And as a consequence, appeal as well. First, call this matter immediately after 2 weeks. Okay.
Item 11.
My lord, I am sorry to interrupt.
Yeah.
Sorry, I am at item 6. My lord has already passed order. I am not in there. Because a lot of things are lots may give a short date because this entire department is going to stall because of that person. So any short date may be given thereafter.
Where is the case?
That item 6, this
yes, doctor.
That,
yes, where is the case against him?
There's a lot of, is a 4th round litigation of this.
No, that's not right. He is harping upon 3 things which impressed the mind of the court. 1, service records are clean.
No, man. That is it. No. I like it. Only.
We should maybe until further orders, no? For a period of 8 weeks. 8 weeks we shall make it. Then you seek application for vacating.
Yes.
They may file a counter also in the name.
We'll file the counter and all these things. I give the details, man. Only son.
8 weeks. In the meanwhile, counter. Along counter.
Counter as a vacation of stay will file.
Along with IA for vacating the stay may be filed.
Who will?
That statement may not be correct.
Let us.
I'll give all the details.
Let us see. Yeah.
Item 11.
Item 11.
Yes.
Is also an appeal by the state involving delay of 125 days, my lord.
You are appearing for
I'm appearing for the respondent. I was filed my objection, your lordship.
125 days.
There's a delay of 125 days, your lordship. I filed my objection also, your lordship. This matter involves with regard to the change of cadre, your lordship. If I may apprise your lordship with a brief fact, your lordship.
Delay, how we will go to facts without crossing the threshold?
Yes, your lordship.
So we will condone delay subject to payment of that money to your client. Otherwise, without money, we will allow the application, which you want.
Your lordship.
Same order. Same order. 125.
2,500.
No, 125.
125 days.
Yes, 2,550. Same order. Within 2 weeks, they will pay. Otherwise, appeal goes.
Lordship may fix a date, your lordship.
It will come immediately after 2 weeks. Yes.
Mobilize, your lord.
Item 12.
Item 12. My lord, this is that grade pay matter. My lord, perhaps recollect, my lords, that the person was appointed as a tax collector. Grade pay of a junior assistant.
with retrospective effect, when his appointment is in 2015. So my lord had asked for two judgments that were there in the government order. Previous order, my lord may kindly have a look at it. The government order, my lord, of the Housing and Urban Development Department is at page 31 of my brief. Page 31, my lord, refer to my lord, so that the order will be clear.
No, you wanted to show one resolution which equated the post. No? In that particular post, they were absorbed.
My lord, they were absorbed as tax collector initially from the year 2007. In the year 2015, they were absorbed as junior assistant.
With retrospective?
No. Never. Never.
Yes.
My lord may have a look at the order that my lord is holding.
32 of the brief, man.
32.
Yes. Our seniority have been counted by the government.
With retrospective?
Yes.
My lord, I'll place. I'll place.
First paragraph.
Pensionary benefits.
Yes.
For service and
financial
towards their service, the unpensionary benefit.
And is not there. So the service for their pensionary.
Yes. No,
for other financial benefit will not accrue. Next sentence.
The last sentence.
Next sentence.
If Lordship allow me only 1 minute, my lord.
Yes.
This writ appeal is not maintainable at all.
Why?
Why I am saying so, my lord? The respondent approached this honorable court, and the honorable single bench has passed the order, consider the benefit of RSCP as well as increments. So basing on that, the government has allowed the benefit under Annex of 14 mile in favor of the respondent. And when the said order was not implemented, the respondent approached this honorable court again.
Whether government has said that a conditional of implementation.
Let me, my lords, place everything in perspective. My lord, my first comment to
yes, it is not maintainable. The
municipality committed to submit.
Challenge the order of government in this writ appeal.
Municipality questions order of the government.
Yes.
It can't.
In the writ appeal, my lord. He can challenge before the writ petition, my lord. But in the writ appeal, he challenged.
I am not challenging that order, my lords. I am only saying.
So that order is in pursuance to the direction passed in the writ petition.
Yes, my lord.
I am only saying, my lords, that the benefit on the basis of which he is claiming that it may be given to his client, that benefit on the face of it is wrong. There have been 4 writ petitions filed, and it intrigues me. And this question I am putting to myself is that not a single writ petition was adjudicated on merits. Every time it has been representation disposal, and pursuant to that representation disposal order has been passed. Every time he comes to this honorable court carrying a representation that is disposed of with an order to take a decision. And finally, on the 4th representation disposal, my lords, only on the basis that similar benefits have been granted to some employees, that is wrong. This benefit has been granted. It is granted, but that is wrong. That is prima facie wrong because the post of junior assistant does not carry grade pay of 4,200 rupees.
But the government has agreed to pay. Who will finance you? It is the government which finances under the act.
My lord, as of right now, my lords, the finance is from the municipality. Because the LFS cadre, the local fund service, so we'll finance it ourselves.
No, but government, which is that section in the generally in all municipal laws, there will be a section which says government can issue direction which the municipal body is bound to carry. Whether such a provision is there in the act? There must be. Generally, they have some similar statutory pattern all over the country, na?
At that point of time, the appointment is...
Answer the question. Please answer the court's question. You, municipality, which is the corporation or municipality?
Corporation.
Corporation. There must be certain, because after 1856, 57 mutiny, Macaulay said that should be a common pattern relating to law that concern regulation of affairs in the municipal bodies. Pursuant to that, most of the uniform laws were adopted. Because of that, we have similar patterns.
The corporation is a separate body now.
That's nobody disputes. It's a corporate body.
It's a corporate body. It has its own. It has its own municipal services cadre, and it has to pay from its own funds.
Suppose if the government has some power to intervene in your affairs.
Let me, my lord,
such a section.
May I, my lords, point out the necessary facts so that then I'll help my lords take their decision. In 2007.
No, question is, he is saying it's not maintainable. The question is, if it is not maintainable, we need not jump into the sea at all.
Ultimately, my lords, this payment, he is now an employee of the Cuttack Municipal Corporation. In Cuttack Municipal Corporation, in across the state, the post of junior assistant does not carry a grade pay of 4,200 rupees. Fact.
The question is, you are speaking of his entitlement. But the writ of the appellate court is asking you that there is a bar now. Read the section, particular section is there. If you have given to all,
but we haven't given.
No,
the government,
it has been given to all.
The government has allowed some payments to be made to employees of Bhubaneswar Municipal Corporation. But CMC, my lords, the government has allowed only on
the act first. Whether government has got supervisory power where it can give direction, etc. Yes, it's there. There will be municipalities act. Do that way. Municipal corporation.
My lords will pass it over. I'll look tomorrow, my lords. Then I'll at least go through the entire act in detail and come back to my lords.
Tomorrow. At the request of final counsel. Finally. Yes. Item 13.
Pardon to mention, well, item 10 and 11, Lordship imposed cost will pay to the council for the respondent because it will be. Yes.
You paid to the council.
My lord is calling this matter, my lord.
Tomorrow. Because twice we have heard this matter. Again, one more. This is waste of time.
Patent illegality, my lord. There is no claim.
Yes. Item 13.
In item 13, pursuant to the notice issued from this honorable court in this writ appeal, my lord, the respondent number 1 who is the contesting opposite party and the contempt petitioner before the Honorable Single Judge Miller. I am appearing on behalf of the respondent number 1, Miller, today, Miller, because it is the first day after passing of that ex parte order on 6th, that is on 6th January, Miller. This order, it has been passed by the division bench of this honorable court, Miller. And your lordship, my only prayer is that, Miller, as for the order.
Coordinate bench has made the order. Honorable Chief
Justice bench, Miller. As for the order, Miller, the contempt proceeding is stayed up to 8 weeks, Miller. My only prayer that contempt proceeding, that brief may be called for, Miller, for the proper adjudication of this case, and your lordship may kindly allow me some time because
how can this court call for the papers from other court?
Miller, that contempt proceeding has been stayed by the virtue of the order passed by this. Because the orders, Miller, passed by in the contempt proceeding, Miller, it is to be brought to your lordship kind notice for the adjudication.
File will not call. It is the prerogative of the Honorable Chief Justice. See that state of Rajasthan versus so and so.
Miller,
it is
Miller, I have to file certain documents.
File it. Who said no?
Miller, for that purpose, I seek 1 week time, Miller. Your lordship may kindly fix up a date, Miller, so that it can be disposed of at the time of orders, Miller. At the stage of orders.
Request of Learned Counsel appearing for respondent number 1.
1, Miller.
Okay.
So far, other respondents are pro forma respondents, Miller. There is no need of their presence, Miller.
For how can you say that? Miller? You are respondent number 1. How can you say they have to say that?
Miller, they have to say they are the opposite party.
Item 14. Yes. You can't say whether somebody is necessary party. It is his cost take. You are only one of the respondents.
Yes. You are assuming I fix up a date, Miller, my friend.
Some date.
Item 14.
Yes.
I had filed this challenging the inaction of the said
14.
My lord, 14 and 15. Now the CJM has passed final orders. The writ petition has become infructuous. That order I have also annexed in this case.
All right. Writ petition number
14 and 15.
So, seeking intervention in relation to alleged
inaction on
the part of the CJM, has become infructuous, CJM having passed order under section 14 of
final order, my lord.
Final order under section 14 of Surface Act 2002. First ordered accordingly, writ petition is disposed of.
14 and 15 both.
14, 15, same orders.
15. Applies to.
Item 16. For the appellant.
Yes, my lord. I'm for the petitioner.
Petitioner.
Yes, my lord. My lord, in this case, on the last occasion, my lord, my learned senior friend has
for feature.
Yes, my lord. forfeiture. My lord, in order to substantiate my arguments, I'd like to focus on the facts first, my lord. My lord, kindly have a glance to page 7. That is the date.
Judgment of Justice Chandrachud Saab. Where is that judgment? Forfeiture is by operation of law.
Yes, my lord, I no quarrel with law, my lord.
Yes.
My lord, kindly have the glance about the conduct of the opposite parties. That I wanted to show.
No, that
Nothing else, my lord.
when things happen by operation of law, conduct of the party pales into insignificance.
My lord, I bow down. But whereas the bank cannot, as per its own whims and fancies, cannot choose the law as their own benefit, my lord.
All these things will not happen.
My lord,
Law is settled now. It says, suppose if you do not make a payment of the remainder of the auction amount, the amount you have already paid, by way, that is 25%, will stand forfeited to the bank by operation of law.
Yes, my lord.
That is the judgment. That's the only point.
My lord, I have only two annexures I wanted to show.
Yeah.
Annexure 9.
What for?
When, my lord?
What for you want to show it?
Yes, my lord. What I wanted to show, they cannot forfeit my amount, my lord.
They are not forfeited. By operation of law.
Yes, my lord. When there is no confirmation of sale under the rules, my lord, then how they can go ahead with the forfeiture of...
No, for the forfeiture, confirmation of sale is not necessary.
Yes, my lord. It is in the statute, my lord.
What
rule.
is
My lord, security interest rules 9. Rule 9.
This
Surface.
Judgment. That aspect of the matter?
Millard, yes. Rule 9.5. That I'll...
Only the judgment only dealt with the 9.5 of security interest rules. And my lord, that judgment is...
No, you have to show... Madam is saying, your sister is saying, our sister also,
Millard,
that unless auction is confirmed,
Millard,
there cannot be a forfeiture.
Yes,
Millard, your lordship, 111 of the paragraph.
111.
11, Millard. The consequence of forfeiture, 111, page 85 of the said judgment. Page 85, 111 paragraph. The consequence of forfeiture 25% deposit, rule 9.5 of the surface rules, is a legal consequence that has been statutorily provided in the event of default in payment of the balance amount. The consequence envisaged under rule 9.5 follows irrespective of whether subsequent sale takes place at a higher price or not. And this forfeiture is not subject to any recovery already made or to the extent of debt owed.
What do you say, madam?
My lord, I am only on the point, my lord. Kindly have a glance to rule.
You said that, no? You're repeating again.
My lord, rule says...
Confirmation is necessary.
Yes,
Apex court says no. The law is what judges say it to be. Oliver Wendell Holmes.
My lord, that is...
111.
111. Law is, Roosevelt, Professor Roosevelt used to say, America has a constitution, but it is what we say, what judges say.
My lord,
How this court matter lands here?
The matter lands here, Millard, because when the petitioner did not pay the amount, we have forfeited in December 2012. And thereafter, they have straight filed this petition before this court.
December 2012?
Without going to DRT. And thereafter, several judgments have come there. So now, since long time has been given, so now, so your lordship may dispose it off, because if you remit it to there, they have also in another writ petition, they have filed challenging my recovery proceeding. So recovery officer has already threatened to vacate this premises. Neither the owner nor the so-called whatever the sale deed has been, they are saying
what is the order you have challenged before us?
I have not challenged. They have challenged.
You have challenged the order of...
Can I read only 9.4?
We are in agreement with you, but the Supreme Court says there need not be subsequent auction at all.
No, subsequent auction.
There need not be confirmation at all.
No, my lord, that is different. My lord, that is different. That is after 75% of the total bid amount. I am only stating about after depositing of 25% of the EMD amount, the sale has to be confirmed that this is the reserve price by which the sale has been confirmed. And from that day, from that day, 15 days will be given to deposit the 75%. But in the instant case, they have written, will take steps for confirmation of sale and issue of sale certificate, my lord.
Millard,
My lord,
they have
kindly-
been given, and the letter has also given 2 dates. Despite that, they have not.
They said we'll make payment.
The payment is balance amount.
My-
But they did not. It means that we have confirmed that you are the highest bidder, you pay the deposit amount. And that is why 3 months or more. I'm just showing.
Can I read 9(4), my
Millard, I will
It
show
is
you.
clearly stated, the balance amount of purchase price payable shall be paid by the purchaser to the authorized officer on or before the 15th day of the confirmation sale of the immovable property, my lord. Confirmation of sale.
Honorable Supreme Court, para 111.
Yes, my lord, that is thereafter. 6. In default of payment within the period mentioned in sub-rule 4, the deposit shall be forfeited and the property shall be resold, and the defaulting purchaser shall forfeit all claims to the property. Then second 6, on confirmation of sale by the secured creditor, and if the terms of payment has been complied with, the authorized officer exercising the power of sale shall issue a certificate of sale. My lord, these are the stages. After 25%, they have to confirmation of sale. Clearly, my lord, it is in the appendix.
But the rule 11, paragraph 11 of the judgment, kindly read.
My lord, that is after 75%, confirmation sale will be confirmed and issuance of sale certificate has to be issued, my lord. My lord, kindly have a glance to 9(4) and 9(6). And here the possession has been taken in the year 2016, my lord, where the auction has conducted in the year 2011. My lord, if they have not taken the physical possession, after 5 years, they have filed a petition before the district magistrate to take over the possession, my lord. How they can give back the possession if at all I would have given 75% of the bid amount when the subject property is subject to the suit, my lord, which has been disposed of and decreed in favor of the landowner. And they could not have handed over the suit property. And my lord, in that judgment, 115 will be at my risk, at my rescue, that under exceptional circumstances, the bank can refund the forfeiture amount. My lord, kindly have a glance to that. 115. And there was a conscious question of law has been framed under exceptional circumstances, what bank has to do.
115.
Yes, my lord.
Paragraph.
Yes, my lord, that is 2024 6 SEC 641. That is the same judgment, my lord.
That Alisha Khan.
Yes, my lord. Whether any exceptional circumstances exist to set aside the forfeiture of the earnest money deposit.
That is due to COVID, Millard. That judgment, Alisha Khan, is due to COVID.
Yes,
Due to COVID. Pandemic. Due to COVID.
Yes, my lord. Mine is also exceptional circumstances. Because of the suit.
Not exceptional circumstances like the pandemic is not covered. Pandemic.
My lord, I bow down. But here, my lord, kindly visualize the suit. My lord, the property is the subject matter of the suit, which has already been decreed in favor of the landowner, and they don't have the property. My lord, kindly have a glance to the additional affidavit where they have given a 13(4). My lord, they have filed before the district magistrate. My lord, how could they can do that? In the year 2011, they conducted an auction, and in the year 2016, they would be filing for possession, my lord, after 5 years. And I have categorically told them that there is a suit pending, my lord. Kindly have a glance to my annexure, my lord. Kindly have a glance. That is at page 87.
Suit for what?
My lord, suit for cancellation of the sale deed.
It is decreed, yes. Therefore, she could not have got that property at all with reversion. That is allowed, decreed. And therefore, that property was very good. But we were at the time, this was property, when we did it. She got the money.
Have you received back entire money lent to the borrower?
No, we have not received. Now, the recovery proceeding has already, recovery certificate issued and recovery proceeding initiated. The present petitioner also went there and filed an intervention petition. That intervention petition has already been dismissed. Question is whether on the ground, what is the locus? You are a tenant and you have participated and thereafter you have not deposited. So you acted like a henchman, what Supreme Court has said, to rigging the value, and ultimately bank could not sell because of this. Then thereafter bank has proceeded now under recovery certificate and recovery officer has already issued notice for vacate this property to the petitioner. So
she is residing in that property?
Yes, residing as a tenant.
As a tenant?
Tenant. So tenant has been used as a henchman by the original, because what is the locus of the petitioner, my lord? If suppose bank will take or not take, or bank will, nobody has come forward, neither the owner nor the purchaser has come forward challenging our action for the surface before the DRT, nor before the High Court, nor before the recovery officer. The only question the tenant,
he is opposing.
Tenant is opposing, having no locus. How? That your lordship can see. I can also see, your lordship, the order. Your lordship see the order. The order which I
give copy to madam.
Yes, I have. You take this copy. And
Lord, kindly have a glance, my lord. My lord, here the only 49 questions whether the forfeiture of 25%
Conduct of the parties.
My lord, I bow down, my lord. Conduct of the parties. My lord, as per the rule, they have not acted in the before taking.
How can you resist taking possession?
My lord, I cannot resist possession.
You filed the objections to that.
My lord, because after this 2016, when they applied for the possession notice, they will again conduct action, my lord.
it is up to the bank.
What you have, you are
concerned. Tenant. How tenant are concerned?
My lord, I am not in that way, my lord. But my lord, I am not in that way. My lord, kindly have a glance, my lord. Because have they acted in the
Conduct of the party.
My lord, kindly.
Have a passed order. They may be wrong in passing the order. You can't go on arguing the matter. This is a writ jurisdiction, limited jurisdiction in appeal. Therefore, we are dismissed.
My lord, I am not against. My lord, only one thing. My lord, my lord.
Will, if you spend more time because of the conduct, we are imposing cost of rupees 5 lakh on your client. We are imposing because you are opposing the bank's action to take the possession of the property. Where are you?
I'm opposing, my lord.
You record that.
That writ petition may be dismissed.
No, question is not that.
That effect.
No, then you give undertaking here that you are giving that property immediately.
My lord, I do that. I'll do that.
You take that property.
Millard.
Immediately.
Millard.
File a memo.
My lord, only one thing.
Otherwise, you are dismissing the petition with 5 lakh rupees cost.
My lord, I am not.
See the conduct of your client. This is public money.
Yes.
He is enjoying that property, maybe in the capacity of his as a tenant. But once there is an order under 14, how can you resist that?
I am not resisting.
You give possession immediately. To pass over. Ask your client to give possession. If you do not give possession, then we are dismissing the petition with 5 lakh rupees cost. How can you retain on the property of the bank?
My lord, can I submit? My lord, can I submit now?
Yes.
My lord, only one question. Only one question.
Yeah.
My lord, if I would have given 75% of the auction money.
The question is not that. Where is your conduct? Why we should interfere at the instance of a person who appears to be mischievous?
No, my lord, I'm not doing that, my lord.
Give that position to the proper.
They will take that position.
No, you. That's all right. That we will look into.
High plans.
That we will look into. First, you give possession at 2 o'clock.
My lord, that I'll do, my lord.
That we will. Now you file. We'll call it at 2. Call your client here. Otherwise, we'll direct the police to.
My lord, I'll do that. I'll do that. I'll do that.
2. You take possession of the property first. First, you take the possession of the security property.
If they will give immediately.
No, at 2.
They will, at 2. They will.
At 2. At 2, you have to report. You should go there, and client also will be there. They will give possession. If they do not give, you come and report to us. We will do the alternative.
Today, there is a strike in the bank, so the people are not available to go to there. So that is why your lordship may give next day, so that we can go and take possession.
When will you go there?
To go to take possession, my lord. Today there is a strike, national strike. So they may not go and
call it day after tomorrow.
And day after tomorrow, they will go and take possession through, because now they have to approach recovery officer. Because
all that is not necessary. This is the High Court.
Miller.
Any order.
Miller.
Serves the cause of justice.
Miller.
Necessary with police.
Day after tomorrow.
Day after
tomorrow, if they will take possession.
Can we record your submission that you will be giving the possession of the property peaceably?
Peacefully, yes.
What are you going to say?
Yes, ma'am.
No, you have to tell it proper so that it will. We are asking you.
I'll file one affidavit to that effect tomorrow. My lord, call this matter day after tomorrow, then I can file.
Tomorrow you will call this matter day after tomorrow. Learned counsel appearing for the petitioner, having argued the matter at length vociferously, now in all fairness submits that the consideration of this petition be deferred by a day, so that her client would deliver back the possession of the property to the bank in terms of order under section 14 of the 2002 Act immediately. First one. She also wants time to file the affidavit to this effect, sold to by her client. First one. The submission coupled with the undertaking is fair. First, call this matter a day after. Yes.
My lord, my first petition about the forfeiture.
You first conduct yourself.
Yes, my lord.
As a full person. Writ jurisdiction is not for loafers.
My lord, I'll do that.
See the wording.
Yes, my lord.
Writ jurisdiction is not meant for loafers. Justice Dhawan's judgment. We will only say, though I am reluctant to use those words.
My lord, I would like to sue one judgment, my lord.
You bring whatever judgment you want to. First, give delivery of the possessions. Otherwise, we will impose heavy cost. We will send police also from here. It's a public property, public money. Yes. Mr. Mukherjee, in minutes we are back.
Item 17.
May it please. My lord, I need 1 week time for little more preparation.
This one?
Yes, 17.
Record at the request.
Definitely.
Item 18.
My lord, this matter already compromised.
After tomorrow. This judgment was to lawyer, final lawyer from bank. Yeah. Yes.
This matter already compromised. And I have
Filing a memo.
I have filed an affidavit to receive the auction memo.
In terms of that to be disposed of. Do that. Who appears for the other side? Admission.
Item 18 minutes, I am appearing for others.
Bank. Mr. Nyamat, they are appearing for the bank.
My lord, this has been settled in the before the
Learned counsel appearing for the petitioner.
Yes.
Petitioner is a borrower.
Yes.
Petitioner borrower.
No, my lord, he was auction purchaser.
Auction purchaser submits that the matter has been compromised in mediation proceeding number 343 of 2025. And to that effect, she has also filed an affidavit of her client sold to on 27/1/2026, this day. First off. Learned counsel appearing, panel counsel appearing for the bank concurs with this submission. First off. The affidavit reads as an correct. In view of the above, writ petition is disposed of. If it make it a point.
Item 19.
Yes.
My lord.
Yes.
So
After a long game.
My learned senior starts, it's not for admission. Just to be taken under for order, because if the court goes through the order dated 6/8/25, all the hearings have already been completed.
Before whom?
Another bench.
Then we have to hear it.
Oh, bless them.
My lord, before getting into you ready? Before getting into that, I'm going to prepare a.
It's a great gesture.
Yes.
Asking the opponent, are you ready? Rarely such gestures are found today, seen today in the past.
Have a walk with him.
Yeah. I've prepared a short notes for kind perusal of this.
Kindly share a copy with
I'm giving it.
your sister.
Monte is online. Skill India. Monte sir, I've got a skill prepared a list. Monte sir, hang
Yes, sir. Yes, sir. I will receive from my junior.
Okay, sir.
Am I audible now?
Yes, sir, you are audible.
Yes, sir. I am for LIC, of which respondent 3, 4, and 5. Pursuant to your lordship's direction, dated 6/8 and 6/8/2025, I filed affidavit and soft copies on the appellant's counsel and these and counsel Mr. Tripathi, who appeared from 1 and 2, the wife and the children. Lordship, kindly see, I have given my stance that after the death of the agent, the husband of the respondent number 1, we are ready to disperse certain amount to the nominee and to them. Lordship, kindly go through the affidavit. I was not audible.
Your client's affidavit.
Yes, sir.
Senior.
Yes. And
Lordship directed me to give our stance, because after amendment of section 39 of the Insurance Act, the nominee, even if the nominee was the appellant, we have to, for beneficiary interest, we have to partake the money.
Sir, we'll come to you. We'll revert to you.
It has been lingering for so many days. It can be closed today.
Yes.
My lord, after a long circle,
yes,
it started from here and we are back to the square one again. As far as this petition is concerned, this appeal is concerned, based on a read petition.
filed by opposite party, respondent number 1 and 2. As far as this,
can you go to the date chart now?
Please,
Please come. 27/6/2010.
27.
What was the event?
27/6.
2010. Death in harness. Death in harness.
Minus.
And your client, sir, he is the son.
Minus.
He is the father of the deceased.
My client is the father of the deceased.
Oh.
And I-
Divakar Sahu.
Son has expired.
Son has expired. One son, he has got two sons. One has expired, the other one is mentally retarded. He is right now with the father. This is the condition, family condition. As far as
he is not a party here.
No. The mentally retarded.
If you declared X as the mental retard,
I have arranged the copy of that.
No,
there is a
never
certificate.
become party.
Pardon?
Is there certificate proceeding?
Yeah. Okay. Whatever it is, he expired on 27/6/2010.
Yeah.
And on 23rd/10/2010, the appellant received the premature death amount of 9,48,229 of the deceased son, where he was the nominee. And same way,
was the nominee.
Pardon?
Your client was the nominee.
My lord. In certain policies, he was the nominee.
There was one judgment of Apex Court, Neelabati versus 84 Supreme Court.
That is not Neelabati.
Neelabati versus something like that. Long ago I read that.
Exactly. That is not Neelabati, Sarvati Devi. Sarvati Devi.
Sarvati Devi.
Sarvati Devi.
Sarvati Devi.
Yeah. I am coming to that, madam. And subsequently, this is a peculiar development.
There is Neelabati also.
Maybe. I have to introduce Sarvati Devi.
Take out Shakuntala versus LIC by Justice Anand Bhaira Reddy of Karnataka High Court. Shakuntala versus LIC. Justice Anand Bhaira Reddy, BYRA.
Shakuntala versus?
Shakuntala versus LIC. Or I do not exactly remember. By Justice Anand Bhaira Reddy. Dealt with a similar question, and the matter went to Supreme Court, affirmed also. Let us see that also.
Okay.
Let's go to Karnataka High Court and find out. Yes, start.
As he received that amount.
Can we tell a piece of our mind to you? What we were taught in law schools, of course, in the chamber also. A nominee is more like a trustee.
Yes. Exactly.
He holds the property for the benefit of title holders. This is what we read.
Exactly.
Any change of law?
Exactly. I am coming to that. I am coming to that.
Okay.
That 100% accepted. I am also of that opinion as far as other laws are concerned. Now we are dealing with Insurance Act and LIC. My point is on 23rd/10/2010, the appellant received 9,48,029 where he was the nominee. Same way on 21/12/2010 and within that period, the respondent one received 5,38,4,867 rupees.
Who is respondent?
When he was the respondent is the wife of the deceased.
Widow of the deceased.
My lord. She received.
Son. Your daughter-in-law.
Your daughter-in-law. My daughter-in-law. She received 5,34,867.
Yes, sir.
From those policies where she was the nominee.
Wherever she was nominee, she got that money.
She got that part.
Wherever you were nominee, you got rupees 11 lakh. So it's
9,48,000. Wait.
How much money you should have received?
Pardon?
How much more money you should have received under the policy?
No, as far as policy, there is two part of it. Policy. First thing is date of maturity. Date of maturity. Once a policy, suppose I have made a policy, all of you, we know that. Once I made a policy and I am believed at that matured at that point of time, then I am going to get that policy
maturity value.
Plus,
you can call it maturity value.
Maturity value, right. That maturity date is fixed. Yeah. When I expired, I died, then that comes a premature death. That is called premature death benefit. Premature death. In this instant case, premature death benefit. They are getting the premature death benefits. Right.
So he died before
In
the
the year-
maturity of the deposits,
My lord.
credits.
My lord. He got this. I got my share when I was the nominee. She got her share in the nominee. The entire transaction was completed by 2011. My son expired on 2010. By 2011, we both got our money. Surprisingly, in the year 2023, my daughter-in-law, the respondent, came to this High Court praying to disburse those amounts which has already been disbursed.
To you?
Yeah, to all of them. We have taken our shares. And that was not, that didn't came into a picture where at the REIT level. When this, the REIT appeal came up and LIC filed a counter. In that counter, LIC disclosed that this money which has been disbursed is the prayer part of the REIT petition, and this Honorable Court has directed to pay that one. We have already taken our share. I have taken mine, she has taken her.
No, you have not taken your share, sir.
You have been, I'm coming to that. I was waiting for that.
Assigned the amount as nominee.
Exactly, as nominee, where I was nominee, I got
what Lordship has
well,
said.
she was nominee, she got that.
Yes.
One. Exactly. We got both of our part of that. Again, asking for the same money on a REIT petition, whether it is
in-law,
other daughter-in-law. Same money, which has already been disbursed 10 years back.
She filed a REIT petition.
She filed a REIT petition. And the prayer part is there. I have quoted that prayer part here.
Consider the representation.
The petitioners thereafter pray that your lordships may graciously be pleased to admit the REIT petition and issue notice to the opposite parties. And after hearing the parties, be pleased to direct opposite parties to consider the representation filed by petitioner number 1 for disbursal of death claim amount along with all other financial assistance, including mature policy amount, her husband in favor of them as being class 1 legal hire. Now question comes. Money has already been disbursed 10 years back. What made you to come here? If the question now comes, this legal hire questions. If that part comes, that's a different issue. And very interestingly, in that REIT petition, she has suppressed that to get that share. As far as legal hire, she has approached
civil court.
And that is pending there. When that is pending there, she has come here.
In civil court, what is the prayer decree column? What is that prayer decree?
That was the ex parte decree. Wait, Rajan. The ex parte, that was ex parte decree that court decided to pay that amount to
her. That
is the
9 lakh.
Kindly sit down. We'll come to you. I will not pass any order without hearing you. Yes. Kindly be seated. That helps you.
Sir is standing up then.
Right. That suit, which is that suit? Civil suit.
Last time read
CS number?
CS number I don't have.
The execution number. The execution.
You have execution number?
Execution.
Wait. I'm giving the number.
Execution number is?
2014.
2014.
Yes, your lordship. Which is still pending. And the order of the learned single judge, which sir is saying, kindly have a glance on the para 8. In the last of the learned, in the view of the matter, the court directs opposite party number 1 to 3 to disburse the death claim amount in favor of the petitioner if the said amount has not been disbursed in favor of the nominee. So there he has not never directed to you give that money to the...
All right. But now suppose if you have already received.
No, we haven't. LIC has given 2 affidavits where they have said the nominee has received already 9 lakh sum.
Kindly wait.
11 lakh sum odd.
Let's, what senior will say, let us see. Yes, sir. There is only direction to consider.
Which one?
The order made, their prayer is for considering the representation.
Exactly.
Where is that order?
Which order?
The impugned order.
Single bench order.
Single bench order. Achha. Single bench order. Right.
Connected field.
Yeah.
Connected field.
Aye. 15 to 21.
Like page 20.
So it is directed dispersing the debt claim amount in favor of the petitioners. Who are petitioner? You are petitioner.
I'm the petitioner. Me and my minor son.
You widow and minor son.
Minor son.
Class 1 years.
Class 1S.
So father is not a class 1.
Not a. His only contention is that father is a 87-year-old and is living with a mentally retarded person. So he should get some benefit from his son. Though he's not a
Brother is
legal heir.
not class 1.
No, he's not a class 1. Only mother
Father is
class
not,
1.
only mother would be class 1.
Yes. And mother has
Father will
already
not
expired.
be. Father's son will not be.
No. And mother has already expired. And mother's legal heir, my husband is also included. And as a legal heir of my husband, I am also included and my son is also included. So what should be the share exactly they should receive?
You kindly be kind to your senior also. Yes,
Sir, I have got no match to him. So
let us.
little bit excited.
Should not have the many times the curiosity kills the cat.
Yes.
Yeah. Therefore, resist
And
your
no,
curiosity.
this thing your lordship has heard with where they, no, not sir, with Justice MS South.
Yeah,
but there
because
you
I
have
was feeling somehow
this all have gone before you.
Facts are known to me that
But
way.
there you didn't pass any of the.
That's why at the beginning I told it started from your lordship and again
It has come back to
this honorable court.
Yes, sir.
Okay. My point is when both of us have taken the amount, there is no point in coming to the High Court with this same prayer and you have approached
Civil court.
Civil court. So
There is a decree.
Pardon?
That's a
Decree in their favor.
When that is pending there, without disclosing that, you have come to the High Court, not in the clean hands. This is the legal part of it.
Anyway, she's there.
No, I'm not that. It is my daughter-in-law. I'm not that. Family is something different. But there is some principle has to be settled. Some principle has to be settled. The biggest principle is nominee. I'm coming to that legal part of it right now. The background is that as far as nominee is concerned,
He's a trustee.
Pardon?
He is a trustee, more or less.
That
was an amendment to the LIC Act.
That I'm coming to that.
2011, 12, something like that. 15. Yes. What was that amendment?
That amendment is
Anybody? Unless law says only XYZ should have.
My lord, prior to amendment, this was the conception. He was the receiving hand. Nominee was the receiving hand, then he has to distribute. This was the prior to that. The law commission.
That happened in which year?
2010.
Now, how you are going to travel to the amendment? Is it retrospective in operation?
No. Then I'm coming to that. Please, 39(7). This is after amendment. Achhi, bhaiya ji.
What amendment says?
Amendment says, subject to the provisions of this section, where the holder of a policy.
We did not tell what the amendment reads.
Amendment
we are asking what the amendment says according to you.
Amendment says the nominee is the beneficiary.
Nominee himself is the title holder.
Why not? Because the law commission report has come up before amendment. The entire law commission says that once we go for a nomination, the intention behind us is that if anything happens to me, this person should be benefited. For this, with this conception, my son has made me nominee where he wanted. After his marriage,
no, but the question is you are banking upon a law which is a post event.
No, in that part in this amendment, it has come up that the provisions of subsection 7 and 8 shall apply to the policies of the life insurance maturing for payment after the commencement of the insurance Laws Amendment Act 1915.
Which section you are reading, sir?
Section 39.
39. Now, special provisions for winding up of certain insurers. Any insuring company. Section 39. No, 39 has a different terminology and intent. Section 39. Different keyword.
Shall I give it?
Or at least you read it. Then I will try to grasp it, then we can pass on.
1 minute, I'll take 1 minute, sir.
Yeah.
Just let me compare. Hey, Insurance Act, LIC Act.
LIC of India Act.
This is of LIC, not Insurance Act.
Insurance Corporation of India Act.
No, Insurance Act.
1939.
1950?
1959.
59.
That's well quoted in your last article on 6/8/2020. 39/7 and 39/8.
Quoted it. And
the
which LIC has, why did he has quoted it there?
So,
Who are the eligible
going
for-
by your argument, I will hear you also. X has a wife and 2 children. One is a certified mental retard. Right? We'll call them as a alpha beta. Alpha died in 2010. He had bought certain policies and nominee was his wife, that is X's daughter-in-law, and his father, that is your client. Correct. After his death in 2010, there was a premature encashment of the policies which he had bought. Under that, the amount payable to the widow is paid. Amount payable to the father as the nominee is also paid. Despite receipt of this amount, the widow and the child approached the writ court. They had obtained a civil decree also. Correct? It is decree saying that if already amount is not paid, you pay it. That is the decree which Madam has read. You were not a party to that decree.
No, he was a
You
party.
were ex parte.
Ex parte. He didn't appear.
Ex parte. But you were not party to the writ proceedings. You were.
I was also party.
Now the question is that Saraswati something you said, na? That's Sharavati, 84 Supreme Court. Under you are only a nominee.
Receiving hand.
Recipient. Means you are only a big postman.
I have to,
You will receive that money. And money has to go to those who are legally entitled to under the personal law applicable to the parties. That is 84 Supreme Court. Now you say you are not only a nominee, you are a title holder to the amount. In fact, nominee metamorphosed into title holder. In that capacity, I am retaining the money. This is the one. In support of that, you want to bank upon the amendment. You say 2015 amendment has brought change in the status of the nominee. He is a nominee coupled with the beneficiary himself, number one. Number two, that is with retrospective effect. That amendment is with the retrospective effect. Because 2010 your son died. And this is brought into force in 2015. That covers the events that occurred prior to the amendment. Which section?
This section 3910.
3910. Yeah. Kindly face it.
The provisions of this subsection. Right. The provisions. The provisions of subsection
7 and 8.
7 and 8.
Let us see 7 and 8.
Fine, my lord. Shall I read?
Yes.
Subject to the other provisions of this section, where the holder of a policy of insurance on his own life nominates his parents or his spouse or his children or his spouse and children or any of them, the nominee or nominees shall be beneficially entitled to the amount payable by the insurer to him or them under subsection 6, unless it is proved that the holder of the policy, having regard to the nature of his title to the policy, could not have conferred any such beneficial title on the nominee.
6 is
6.
your nominee.
Where the nominee, or if there are more nominees, then a nominee or nominees survive, the person whose life is insured, the amount secured by the policy shall be payable to such survivor or survivors.
This is the different thing. You say that where father is the nominee, their widow is not the nominee. It is different. Not that under one column, both are nominees. There are no. So this 6 is talking about.
Speaks of survivors.
Yeah.
What is meant by survivor?
Again, may I read again? Where the nominee, or if there are more nominees, nominee or nominees, then a nominee or nominees survive the person whose life is insured. Thus, amount secured by the policy shall be payable to such survivors.
That is nominees.
The nominees. The nominees. It is for the nominees.
6 and 7 are made retrospective operation.
10. The provision of subsection 7 and 8 shall apply to all policies of life insurance maturing for payment after the commencement of this Life Insurance Laws Amendment Act 2015. The policies that maturing after 2015, it is applicable to all those policies. Policies, nobody makes it for a day or two. It's a long term. And I have given a list of the details of the policy maturing. Where I have already received answer. Here, but I have got a column.
Come to 11 also.
Pardon?
11.
Where a policy holder dies after the maturity of the policy, but the proceeds and benefit of the policy has not been disbursed to him because of his death. In such case, his nominee shall be entitled to the proceeds and benefit of his policy. A person has made a policy. The policy matured. The day it matured, before disbursing that amount, he expired. Then the nominee will again go in. So nominee has given the
policies which were made were to mature after 15.
Again, this is a list. I have given a list of it. I have given that.
This is prevent.
You want us to refrain from hearing them?
No, sir. They have given.
Sit down. Really sit down. It troubles us. You are troubling because you are interjecting. It's a very important matter. Suppose if we lay down a wrong law.
Yes.
And if some observation is made against the judges.
I beg pardon for that.
Therefore, kindly be silent.
Please go through that. I have given a chart where it has been mentioned when the maturity is.
No, let us understand the language of the section. The provisions of subsection 7 and 8 shall apply to all policies of life insurance maturing for payment after the commencement of the Insurance Laws Amendment Act 2015. How it matures? Means what? Matures means what?
Matures. Once a policy is
whether it is defined under that?
Yeah, I am coming to that.
No, whether there is in the dictionary clause of the act, is it?
That I have to find it out. Maturity.
I
have to find it out.
That has intervened.
That maturity would mean the order.
That one only.
Yes. Now it is considered the whole thing goes.
No, that word is not defined.
It is not defined.
Provisions of subsection 7 and 8 shall apply to all policies of life insurance maturing for payment after the commencement of the Insurance Laws Amendment Act 2015. No, it will not travel to section 10 because the policy becomes payable, whether you call it as matured or not. And there is one famous book by Law of Insurance by Srinivasan. The famous book which Apex Court has referred in half a dozen judgments. Srinivasan. Under by Srinivasan. Law of Insurance.
Law of Insurance.
By Professor Srinivasan. Madrasi has written that. A very wonderful book it is. See, your case does not travel to subsection 10 at all.
May I ask why?
Wait, policies which will mature is one thing.
Exactly.
Policies that have no occasion for maturing at all because the buyer of the policy is dead.
That is called premature death benefit. That is premature.
Correct. But
Death
section
benefit.
is not, the section does not use your terminology nor any other terminology indicative of this meaning. If they wanted to cover the cases of death also, they would have made a provision.
Obviously, if this situation would have never come to the mind of our legislator. However, I am coming to that. I am strictly confining myself to the date of maturity. Now question comes, let me explain what I feel as far as my knowledge is concerned. Date of maturity means I made in policy. In every and each policy, there is a certain date of maturity that we all know. That is the date of maturity.
But the
Maturity.
very contract is contingent in nature.
Pardon?
The very contract is contingent in nature.
My lord.
In the event of an eventuality, this will occur.
In the event,
the policy is not to see you, but it is to mature only.
Exactly.
Death is not
I am on that.
contingent at all.
Death is not.
Death is inevitable for everyone.
Yes.
That is inevitable.
You will be Shatayushi is another thing. I may not be. That's the
So maturity date cannot change. Maturity date is fixed.
No.
Date of maturity is fixed.
No.
Once a person dies,
Please.
my lord,
What my brother is saying is, though death is certain,
though
death is certain,
my lord.
the date of death is contingent. In that sense, yes.
Okay.
We are all under the sentence of death.
Okay.
Myself, my brother, you perhaps, madam, you agree with this? Yes, you also will be. But question is, when one is going to die, is contingent. There are English judgments.
Yeah.
Date of death can be contingent. If he dies within 15 days, in the Mahabharata, there is the Dhritarashtra's, there is Arjuna's comment on Dharmaraja. Because Dharmaraja says, come tomorrow to take arms. We are all tired. Come tomorrow. Then Arjuna says, you are so sure that Yama will not come before tomorrow. Then you are greater than Yama. Something like that it happens. Anyway, if the parliament, because law is, the parliament understands English. The parliament understands needs of the people. Therefore, the statute is what the parliament says in so many words. subject to purposive theory of interpretation, constructive, so many things are exceptions. But law is what it is. If Parliament wanted to cover the cases of death that have occurred prior to enacting of the 2015 amendment, it would have simply said, it would have added one term there, where policies are going to expire or attain maturity, or money under the policies becomes otherwise payable, maybe because of death. That term is absent, number one. Number two, insurance is extension of law contract. All standard authors like Srinivasan, Raiden, they say the law relating to insurance is a notional extension of law of contract. Because buying the contract, the policy is a must. From there, these things emanate. So it's an extension of law of contract. If that is so, how can you infuse a date anterior to the coming into force of the Amendment Act? This is our question. This is the only point. Rest of things will fail into it.
Exactly. This is the only
number one. Number two, you have suffered an ex parte decree. An ex parte decree is nevertheless effective decree, on par with a decree obtained on full trial, full-fledged trial. There is a decree. Decree will come in the way of maintaining appeal. You may take proceedings for setting aside decree, etc. Even if this order is set aside, that will be very academic because decree operates. Therefore, two questions you have to answer now. Appeal is not maintainable because you have suffered a decree, decree is intact. Law does not differentiate between an ex parte decree and full-fledged trial decree when it comes to enforcement. Number two. Number three, all law is presumed to be prospective. All substantive law is presumed to be prospective. All procedural law is presumed to be retrospective unless the contrary is indicated by the lawmaker. Then how are you going to answer this question? And you are not class 1A. Your son, that is brother of the DC, is also not a class 1A.
Till that time. But
his father's son is also not a class 1A.
Now I am coming to that. First thing, I am not a class 1.
Therefore, you cannot claim
Accept.
that. Yes.
100% accepted.
Correct.
And my daughter-in-law, the respondent, once claims her share being class 1 higher. Right. And that point, that settlement, she has received an amount. And class 1 legal hire are 3 persons. C.
You are not.
No, I am coming to that. C means my daughter-in-law, the respondent.
Her son.
Her son. And my wife. Means
You are not there.
I am not there.
Widow, when you became widower?
My wife expired just 3 years back.
So
yes, she was surviving that. At that time, sure. If that is the point.
Under that, you will be claiming.
Yeah. Now I become the class 1 legal heir. As me and my son, retarded son. That comes. If we are going for that share, they are going for that share. She is there. They are 2 and we become 2 again. This part. And from the initial stage, when she got her money, she didn't raise this question. Neither she or me. We took our own part of it, what we received.
After amendment, all
that,
these things.
Yeah, exactly. This came up to this thing. When this has come up to this place, now, and surprisingly, she has not uttered a single word about the civil suit in the writ petition. She has totally suppressed it.
You have said that.
And the court has passed a direction which on a matter which was not under the consideration of before this court. These 2 points I raised it. Third thing is that I want this honorable court to analyze this maturing of payment. I don't, for that I believe on that, maturing of debt. The date of maturing is fixed. Once a person expired with that is premature, then definitely. And on that, there is also difference between the payments also.
Kindly see.
Again.
Maturing for payment after the commencement of the insurance.
That is my worry.
Not date of maturity.
No.
It matures because the policy buyer is dead. It matures when the buyer dies or when the maturity date is attained. Only these two incidents. You mean to say, where policy amount under the policy becomes payable because of the death is not a maturing of policy.
That is not maturing amount.
What we are saying that, but unless you give some ruling, something like that.
No, I have to get in policy. Maturing amount means the amount I insured. Suppose I have insured 5 lakhs. I am paying premium.
You have to show that.
That I have not got this. I have to get an insurance policy of mine.
No, we will not give time. We have heard you now.
Okay.
Over.
Let me just submit.
Yes.
The maturity time. What is maturity money? The maturity money is the amount insured plus the interest plus bonus. That is matured amount after the certain date that is given. The policy mature and they are going to pay for the matured amount.
No,
matured payment.
It is liar's version because it is going to benefit your client. Maybe you also, because he will get money, you will get, that's another thing.
Nice.
Question is, where is some authoritative ruling or opinion of stalwarts in the field? Where is that research?
My lord, I think this court is going to settle the
We will settle, that's another thing.
That
Whether
court is going to settle
assist
that.
or not. Your assistance is lacking.
No, I am saying it right now. Just a minute. 1 minute.
Your whole case is, it is retrospective in operation.
Exactly.
And you want to defeat the writ petition on the conduct of the party.
My lord.
These are the two things.
My lord.
But you have not taken any action against the decree for recalling the decree.
No, we have filed it. It is pending there also. It is also pending there. It's not that we have not filed it. And very interestingly, came to know that execution petition they had filed. They would run it since long. That we got it. However, we have filed
any number of
it is pending before there.
Whether withdrawal of execution in your state operates as res judicata? No. Unless it is res judicata.
No. Just I intimated. It's
nothing.
Sure, 50,000.
No decision of any high court on the last 10 years.
No, nowhere it has been dealt. For the first time this is coming, not even in Supreme Court. This LIC matter has not gone to anywhere. Wait. There is one thing. There is a judgment of Delhi High Court.
Saying?
Coming to Shweta Singh Huria versus. They have extensively quoted the Law Commission reviews.
What the law declared? Nowadays, there is an allegation against the judges that instead of writing the judgments, we are writing the thesis.
Shall I read that one?
Yes. No, what is that? We'll read that one also. What is the question treated?
Here this is, since the trial court has not considered the legal issues of 2015 Amendment into Act raised by the appellants, it would be appropriate to remand the matter back
and decide it. Where is the decision?
That is
the decision. We have been taught in the law school. A decision on the questions traded.
No, it has not been decided.
Then why are you putting that?
Not in this. Just to apprise you that something has happened. It's not that. For the first time, it is coming to such a matter is coming to this. And date of maturity.
Kindly come to subsection 11 that supports our view. and defeats yours.
Where a policyholder dies.
That eventuality is taken care of in the next section.
No, my lord.
Kindly see that.
Where a policyholder dies, the maturity dies after the maturity.
Yes.
So dies after the maturity.
Therefore, the Parliament knew the possible death of the policy holder.
Well, shall I move 2 words again? Where a policyholder dies after the maturity of the policy,
correct,
but
not paid.
But the proceeds and the benefit of his policy has not been made.
Yes.
It is that, but this doesn't suit to my circumstance.
No.
I have expired prior to maturity.
That's true. Therefore, your case does not travel to 10 also. Because death of the policyholder in a particular situation is contemplated by the Parliament. But the situation which the case has known, that is left untouched by the Parliament. Therefore, Parliament intended what the law was earlier, that should continue, except in subsection 11. Obvious that way, because it's a parliamentary intent is clear. Very strong presumption. Great authors like Grayson Statutes, Sutherland, and Crawford, Maxwell, they are of the opinion the court should interpret the law as it finds from the text of the statute, subject to exceptions. Where is the question of exception here? Law is as clear as Gangetti quarters. No scope for interpretation at all. Otherwise, it would have said, this amendment shall be deemed to have come into effect from date of so and so, which will be anterior to this. That is not the shall. The word used is shall. In subsection 6, 7, 8, 10, 11. 10, not 11. In all these provisions, the word used is shall. Shall indicates elements of mandate coupled with the future aspect, operation in future. Unless it shall be deemed to have been, that is not like that.
Shall means it's mandatory.
Shall be mandatory.
Mandatory.
But that way, but that our point, focal point is not mandatory or directory.
Right.
Our focal point is whether it is prospective in effect or retrospective in effect, only for those limited purpose.
My point is, I am sticking to only, my submission is based on only one thing, maturing for payment.
It matures for payment on death also. The policy matures for payment on death of the policy holder. That is the beauty of insurance policy.
My lord, that is the difference that I want to present. Exactly that document I am not having. Maturity is different from premature death benefit. Maturity means the amount I have insured. After the maturity, I will get back that amount, insured amount, along with interest and bonus. And in premature death, one minute.
Srinivasan rights, which you have not seen, which I have seen.
No, I am not.
With humility, I am saying,
My lord.
since you are insisting upon the argument.
My lord.
Srinivasan rights says, the policy of life insurance will come into effect and the benefits of the insurance subject to the clauses to the contrary would reach the hands of the insured on the death or on the maturity date, whichever is earlier. The very object of insurance is that. Insurance is in the event, even vehicle insurance. Even vehicle insurance. In the event accident happens, in the event I die, even otherwise also, because in England what happened? Most of them stays where they became, the longevity increased. Therefore, the insurance companies became very, very profitable, insurance business. Then they said, all right, even if you are not dead, still we will give you benefit in West. This was an attractive economic policy. Any standard book on law of insurance will mention that. It happened in England, in English, during English people. They did not go for insurance at all. Because the medical facilities were so good that almost the mortality rate came down considerably. But if I'm certain to live for long, why should I should buy insurance policy? We'll buy an accidental insurance policy. Then they said, you need not die. Even during your lifetime, we will give you money, provided the period is for such and such day. That's how law of insurance has taken the graphical growth. Any standard book will say that. And kindly do not mistake our words. Sometimes we say something more than what is required.
Now coming to the CR part of it, as being in class 1 legal heir right now at the present circumstance, class 1 legal heir, me and my retired son, both come down class 1 legal heir. That is to be, I think,
that you have to get adjudicated in a civil
exactly.
Because mother is a class 1 heir, and after her husband, after her death, she died after the death of son. So she also will be one of the sharers.
Exactly.
And she will be sharer in the money payable to you also.
Yes, Your Lordship.
Yeah,
we have never said.
Previously, what they have received also, in that also.
We are ready.
One third.
We are ready to pay whatever we have received, her share, provided they have also to pay us back whatever they have received. Because the LIC says they have received an amount of 9 lakhs amount and an amount of 11 lakhs amount. 2 affidavits are given by the LIC officer, and where he is saying that my mother-in-law is also one part. So out of 3, she is 1. And after her death, his son, and my husband also, late husband, also became the legal heir. And then there also I have a share.
All equal.
There also I have a share.
Widower, and children.
Children. So there I have a children. There I have also the legal right. So they have to adjudicate the whole.
Take up. Appeal dismissed on the following grounds. Number 1. Admittedly, the appellant was a nominee in respect of certain policies, and on the death of his son, policyholder, he has received that money. First of all. The respondent number
1 and 2.
You were only nominee.
1.
Respondent number being the daughter-in-law of the appellant, that is, widow of the policyholder, was also a nominee. Kindly be seated. And she has received the amount in respect of her nomination. The apex court in 84 Supreme Court said, a nominee is not more than a trustee or a postman. And therefore, the amount received under the insurance policies of the kind will be held by the nominee in trust for the benefit of title holders, according to personal law applicable to the parties. First of all. The fact that the appellant had received, appellant and the first respondent have received the amount as stated, would not give a cause of action to maintain the appeal against order of the learned single judge. Number 2. Secondly, the respondent numbers 1 and 2 have obtained a decree in the civil suit, to which in civil suit in OS number or CS number 156 of 2011 at the hands of learned civil judge, senior division, and the appellant was a defendant to the same. First of all, the said decree is put in execution. The said decree, having been obtained ex parte, has been put in execution, enforcement, in execution number 7 of 2014. First of all, we are told at the bar that this execution petition has been withdrawn.
Your Lordship, I do not have any instruction whether it is.
It said it.
He's saying, but I don't have any instruction.
You said that. You don't quarrel with us. Otherwise, we will allow the petition. We'll allow the appeal now. We have other reasons.
No, I'm not
Allow the
quarreling.
appeal. Appeal is allowed on the following grounds.
I'm not quarreling. Your Lordship has taken it in a wrong
Kindly be
posture.
seated. Therefore, you have said it. Kindly do not disturb when we are giving dictation. Be little kind to the judges. We are not taking your money. We are not nominees. We are only deciding. And without much preparation, everybody coming and saying all these things and wasting the time of court. Nobody is doing jurisprudential arguments. All substandard. Yes. Counsel for the appellant submits that the said execution petition is withdrawn. However, counsel for the respondent in a raised voice says that her client has she has no information. First, we have objection against the voice raised. Though said objection, voice raised in the court when judges are so kind. First, next point. The above being said, counsel for the appellant submits that already steps are taken to recall the judgment and decree obtained ex parte by the respondents. First, therefore, much we will not say in that regard. First, learned counsel for the appellant is also justified in telling that after death of his wife, who is none other than mother of the policy buyer, the policy amount would accrue to the estate of said deceased, she being one of the heirs in class one heirs under the Hindu Succession Act 1955, therefore, on her death, appellant also will succeed to her estate in a particular proportion, along with others. First, last, all the above things, although have not been specifically much discussed by the learned single judge, the impugned order is structured on those inarticulate premises. First, in the above circumstances, this appeal fails subject to the following. One, the court below, the court of senior civil judge Denkana shall consider appellant's application for recall of the decree secured by the respondents in subject suit. Seventh, the next paragraph. Even otherwise, it is open to the appellant hearing to plead. We would not have granted this, but we are giving because she intervened. Even otherwise, it is open to the appellant to seek carving out of the share that would have fallen on him on account of death of his wife, who is none other than the deceased mother of the policyholder. This he can do if and when the decree in question is put in enforcement, or a modified decree, or any decree that may be passed in future in favor of the respondent. Next one. We do not agree with the submission of learned counsel for the appellant that the 2015 amendment to the LIC Act is retrospective in as much as subsection 10 does not contemplate policy becoming available for amount under the policy becoming available on account of death of policyholder, which aspect is not contemplated under subsection 10, nor subsections 7 and 8 on which 10 is structured, although such an eventuality is contemplated in subsection 11. First, next time, it is a settled position of interpretation of statutes that the Parliament understands English language and it enacts for the needs of the people. And when something is not enacted, the courts cannot intervene by employing the maxim omissus causa. First, quote Crawford on statute. Crawford on construction of statutes, Crais on statute, CRIES, something like that, CRAIS, on statute. Thank you.
I beg your pardon, Lordship. I didn't intend to interfere. Only Sir asked what is regarding. That is the reason why I said.
Matter which is likely to take some time because there are two appeals filed by both the sides. Both are agreed by the judgment of the learned trial court. Likely to take some time. What I gather is your has already fixed two matters at 2 p.m. today, and one of which at least is going to take substantial amount of time. Besides, there are Passover matters. May I request your lordship to fix a date, my lords, where at 2 p.m. so that these matters my lords, I would pray for 9th of February, 9th, 12th or 13th, whichever date is convenient to your lordship.
12th or 13th. 12th we'll have.
I have the petition applied in person.
In these matters?
Yes, in my.
Well, you are coming from which place? Cuttack. No problem.
No, they have taken already time.
No, I'm not seeking adjournment, right? It's not going to be tomorrow. No, tomorrow not possible.
We are not PT Usha. We don't run that fast.
Sorry, man.
So on 12th we'll have. 12th any problem?
2 p.m.
No, I don't have a problem, but time is.
Time is always runs. Nobody can halt it.
Okay, ma'am.
Yes.
12th at 2 p.m. your lordship.
That we don't say because if there are other older matters, we cannot give preference to your matter.
Your lordship may indicate subject to older matters at 2 p.m.
Let us see. Next.
One password.
Yes, call.
Item 4.
Before my lordship starts, my lordship only can apprise your lordship what are the facts so that.
What facts? We have already seen, only we have to assert. This is only 227 writ appeal. Yeah. This is not, see, in 227.
Lordship.
Limited jurisdiction, not no much argument at all.
Lordship.
Only in 226 you can raise your voice, not in other matters at all. The 227 is between court and the petitioner. That's all over. Yes, show that.
C by 2 and D by 2.
Difference is not maintained in 226.
And I think on the application, I already been
even if it is a breach of law, still will not be anything. Yeah.
E by 2 and D by 2.
Annexure C2 is a letter written by whom?
The Panchayat Executive Officer, Your Lordship. There he has explained that his serving of notice, taking a photograph of the notice being served, and the endorsement made by the Sarpanch.
The notice is to be served by post.
That is the D by 2, the postal. And also we've written.
Law prescribes mode of service.
Yes, by
you
speed.
have a strong reason to decide that mode is not.
D by 2, Your Lordship, by speed post, you said.
Page number?
And also the body we have written.
Yeah. This is a law says certificate of posting.
Yes, Your Lordship.
It is sent.
Yes, Your Lordship.
What all was sent?
The requisition, the resolution, and the notice.
No, how we should know? The content reached, we can understand. Presumption is the cover reached the addressee. The contents reached the addressee, or what are the contents? These are not, there is no such presumption at all. In fact, there is a famous book by Majumdar, A.B. Majumdar, on law of notices. He says, under the Post Offices Act 1905, and the rules made thereunder, where an envelope is sent by the post, duly stamped, fully addressed, presumption is envelope has reached the addressee. That presumption generally will not extend to the contents of the envelope. Allahabad, 1920 Allahabad. So where is the material to show that these things accompany in your this? Where have you noted what all is sent to him? Where is the note sheet?
The records of the officials concerned, Your Lordship.
Which place it has to come from?
Come from Jaipur, Your Lordship.
Jaipur.
Koraput district.
How many kilometers?
This is around 540 kilometers.
How? Then next week we will have that. You satisfy us because he has raised a point. Let us know. Call next week at the request of learned AGA Timothy. So who shall keep the original records for the examination of the court. Okay. Next.
Lordship, may I pray for entry, Madam Lordship? May I pray?
Because learned single judge has already seen that.
May Lordship permit 2 lines suffice, Lordship. Yes. Lordship, kindly have a class 24 C and D.
Well, I have, in fact, I am the author of that.
That's true, Lordship. So C and do the more independent, Lordship. So C picks up resolution of the question mandatory. D for notices, Lordship. And both the counts they have failed, Lordship. I have endorsement, I with objection I have received.
When a meeting is scheduled?
No, only Lordship, they have already unseated me.
You have unseated me?
Unseated me, Lordship.
Let us, nothing will happen. Yes.
But same heading next week. Same heading.
Yes, it does. Yes.
Item 24.
86. So I've submitted a convenience compilation. There are so many additional affidavits filed in this case. Lordships may refer to the convenience compilation.
Convenience compilation.
It's in the.
Do you have one hard copy with you?
Well, I've submitted. I've filed hard copies. It'll be there. Got a convenience compilation through.
Public Service Commission is in appeal now.
Yes, ma'am.
Yes.
Hard copy. Agro filings.
Any urgency in the matter?
The urgency being these candidates, doctors have been selected. There were 14 wrong answers. They did not, even if my learned friend has given all the dates in his writ appeal memo date chart, that will suffice the purpose. Because all the dates my learned friend has stated in the appeal memo date chart. Here at the two dentists.
Yes. Start.
Grateful. Before your lordships open the paper books.
Yes.
There was an advertisement published for recruitment of dental surgeons.
Dental surgeon?
Dental surgeon. And the examination is in the form of a written examination of MCQ type, multiple choice questions. Sir, upper convenience compulsion.
Yes, sir, I got now.
Sir, upper convenience compulsion.
Okay. It's a recruitment to the posts of dental surgeon.
Dental surgeon.
How many posts?
There were 126 posts.
How many were notified?
126 unreserved posts were notified.
You are.
We are concerned with 121 because in 5 cases, in respect of 5 posts, there were interim orders passed by this Honorable Court which have not been filled up. So, we are concerned with 121 UR posts.
Though 126 was notified.
Yes, ma'am. I will show your lordships.
Others were 5 were interdicted.
5 were
in a writ petition.
Yes, ma'am. They were injuncted by way of writ petition.
Not to fill up.
Yes, ma'am. After the examination was held, we published a select list whereby 121 UR candidates were selected. And
what kind of examinations?
Well, this is an MCQ type, multiple choice question type.
Held on? Exams were held on? All right. When it was notification dated?
Well, then may take your lordships to the documents then.
Just to ask you. Date of the notification.
The notification is dated.
Advertisement.
Yes. Dated 17th of March 2018.
Yes. Okay.
Well, is the
examinations were held on? It is a matter relating to recruitment.
Because it was held in 2019. No, 18.
Give us date. Rest of the things you need not say. Sit down and say, what is the date on which exams were held? Mr. We do not understand, I tell you.
I'm sorry, when
the recruitment related matters are taken, when recruitment notification, which you call as advertisement like tender, anyway, advertisements was issued, how many sanctioned posts, how many were notified, when examination took place, when selected interview took place, when selection list was prepared, provisional, when objections were filed, by whom, when select list was finalized, when the matter went to recruitment authority, recruiting authority, appointing authority. These are questions. This will decide the parameters. What is the UR category? What is the reserved category? Horizontal reservation, vertical reservation. End of the matter.
It was 18/8/2018.
No, that
They-
is publication of the marks.
Recommended the names of 171 candidates.
The examination was held on 6/5/2008.
6/5. 2006.
6/5 balance is the date on which the respondent submitted the application.
That's written here in your date chart.
The respondent number 1 submitted his application and appeared in the written examination.
Anyway, so this is how service law operates in the matter of the good.
I apologize.
So in 2018, exams were held.
Yes.
The date being 6/5/2018 is the date
No,
of.
that he says that date appears to be wrong because brother pointed out
No,
the
it's
same
not.
date from his write-up.
No, my lord, this is the
It
date
can
I
be
have.
correct?
Yes, 6/5/2018
2018.
is the written examination held by OPSC.
All. When results were announced?
My lord, they announced the result
On 18th of August 2018. So it was 9th of August 2018. 9/8/2018.
Then when the interview they were called for, and what is the ratio of interview?
Well, there is only a written examination followed by document verification.
That's all.
That's all.
No interview.
May I just add a caveat? The question is this. The written examination was held. 200 marks allotted to the written examination and career marking was there. No interview, physical interview. Career mark of the students plus marks secured in the written examination shall be taken into
It's a admixture. 50% from here and 50% in the examination.
Examination. In that view of the matter, they prepared a list. They did not publish the key answer.
Anyway, the select list was published on which date?
I'll come to that. Select list was published on 9th of August 2018. I'll come to that. 9th of August 2018. Thereafter, my lords, on 18th of August, I published the cutoff marks, and more importantly, on 20th of August,
Cutoff marks on
18/8/2018.
For what purpose it is?
Cutoff marks are the marks which have been secured by the last selected candidate. So we declare, my lords, that under the scheduled caste category, the last person selected secured X marks. For UR category, UR women category-wise cutoff marks are published. And my lords, on 20th of August.
The extent of reservation operating in your state?
But it's scheduled caste, scheduled tribes, and for SCBC. SCBC is 11.25%.
SCBC, OBC.
OBC. It is 11.25%. And well, it's 27%
27%
for
27.5.
5 state. 22%.
What was the cutoff marks? What were the cutoff marks?
Well, I will show your lordships that. Well, it will be easier once I show your lordships that. Well, I'm just giving your lordships a broad view of the matter. When I published the answer key, I received multiple objections from various candidates that the answer key is wrong. Several answers are wrong. And after certain writ petitions were filed, a mandamus was issued that a revised select list be prepared in accordance with the new answer key.
You released a new key answers also.
We released a new answer. We sent the matter to a fresh expert committee, and in accordance with the recommendations of the new second expert committee, we published a revised select list.
They were revalued.
Yes, ma'am. Certain questions were revalued, and
is it true?
No, ma'am.
No.
I will show you lordships. I will show you lordships. No. I will show you lordships.
Only 1 minute.
Then let me go straight to the
Only 1 minute.
I'll show
Only
you
1 minute. Within 1 minute, I will finish.
Yeah.
My lord, the examination was conducted. Thereafter, some of the candidates appearing in the examination, they asked for to supply a copy of the key answer to the OPSC before the publication of the result. They did not supply this. They approached the State Administrative Tribunal for a direction to supply the copy of the key answer.
What tribunal said?
The relevance being The answer.
Tribunal said what?
Tribunal rejected this. Then they appealed this honorable court. This honorable court directed you supply the key answer to the candidates. Then, before supplying the key answer, even if publishing the same, they recommended name of 171 candidate because the advertisement was for 198. My blood friend is not correct. My learned friend is saying
He specifically said
198.
121 you are candidate.
The advertisement is for 198 posts.
Only 198.
198 posts. The OPSC, without providing the key answer to the candidates or publishing in their website, they recommended the name of 171 candidates to the government for their appointment.
Even in the face of the High Court order?
No. There is no High Court order. Only they recommended. Since there was a direction of this honorable court to publish the key answer, thereafter they published, after recommending the name of 171 candidates, they published the key answer. From the key answer, 6 candidates found 14 key answers are wrong. Key answer prepared by the OPSC.
Totally, how many answers? How many questions? How many answers?
200 questions, 200 answers. Out of 200 answers, candidates securing less than 0.5 marks, they have been rejected. Whereas 14 key answers were wrong. Only 6 candidates made a representation to the OPSC chairman. You kindly see these question answers prepared by the OPSC are wrong in view of these big books and foreign journals. Then OPSC, after receiving this so motto, without any direction of anybody else, sent this to an expert committee consisting with certain professors.
What the committee said?
The committee found 14 answers published by OPSC are wrong.
When complaint was about 6. They found out not only 6, they added another
14 question answers.
6%.
6 persons made representations. OPSC on their representation without any court order, OPSC voluntarily
on its own did.
On its own constituted a expert committee and submitted the key answer for examination. Upon examination,
let him argue. You can reserve your reply argument. Let him argue.
No, thereafter, the OPSC got the report on 5/10/2018. Thereafter, they did not correct the answer of anybody else. Therefore, the petitioners, present petitioners, were approached the Honorable State Administrative Tribunal then. Then the matter transferred to this Honorable Court after abolition of the same. This Honorable Court, Honorable Single Judge, passed an order that in view of the expert committee report, you consider the case of the petitioners. Petitioners were 6 in number. And if they are found eligible, give them appointment or else no.
That order is challenged before us.
No. Thereafter, they passed an order.
Let me examine Lordships the documents one by one, then it will be easier, my lord.
Yes.
The Lordship will kindly have.
Let us go to how we have understood the case. Go to the learned single judge's order.
No, there are certain facts which are yet to come. Let's just quickly go through the convenience compartment. The question of law that is before your lordships is whether the learned single judge has held that the Odisha Public Service Commission does not have any jurisdiction to change the cutoff marks. Our submission is that cutoff marks are not changed by OPSC. They are not
the result of redoing the exception.
It is a function of the number of posts and the marks secured by candidates. It is a function of the answer key. When the answer key changes, the cutoff marks will change. And I will show to your lordships that the respondents have not cleared the first cutoff as per the old list, and they have not cleared the cutoff as per the new list. Therefore, they have no right of appointment.
Learned single judge directed what?
Learned single judge said that the revision of the cutoff marks was impermissible and therefore directed the OPSC to apply the old cutoff marks to the new marks of the petitioners, to the new marks of the respondents. That is the illegality in the order. if the answer key changes, the answers of all candidates change, and therefore the answers, the
Whether
marks,
all the answers of all the 121 candidates.
their marks will change.
No,
Their marks will change, man.
I have not completed the sentence.
I'm sorry. I'm sorry.
Whether after, see, you constituted the expert committee. And the expert committee said 14 answers are wrong. Okay?
Yes.
After that, did you undertake mass level re-evaluation?
There was a direction from this honorable court to reevaluate the answer sheet.
Did you do that?
We did that, Manoj. We published a new select list. Normally,
Based upon that exercise.
based upon that exercise.
When that exercise was done? When a committee was constituted, give the dates just.
That's committee was, may I just take your lordships through the
Expert
documents one by one? It will be easier.
Not be necessary. Expert committee
Because the expert committee was formulated.
constituted, wide order dated.
The expert committee report is dated 5th of October 2018. And this honorable court, by order dated 15th of November 2021,
Expert committee report is dated
5th of October 2018.
It said 14 answers were wrong.
Mas, the order of the learned High Court is, of this honorable court is.
We are asking you.
Yes, ma'am.
The expert committee said out of 200, 14 answers were wrong.
Yes.
Is it correct?
Yes.
Just note our facts. Total notified posts were
198. We are concerned with the unreserved category.
Recruitment notification dated 17/3/2018. First off, 198 posts of dental surgeon were notified. First off, of them, 126 were UR.
121 or 120? Oh,
126 were
126 were UR.
Common. And process in respect of 5 of them was halted in various WPs.
That is not of the pleading.
Anyway, it's his version. Then next point, exams were held on 6/5/2018. And results were announced on 9/8/2018. First time. It was for 200, it was MCQ dash 200. First time. Scheme is 50% of academic performance would be added. Which academic
30%. 30%.
30% of academic performance would be
In
added.
10th, 12th, and bachelors.
Collectively.
Yes, but 10% 10th class, 10% 12th class, 10% bachelors.
The following way: 10% matriculation, 10%
plus 2
PUC, pre-university course,
pre-university,
and another 10 in final year degree,
graduation degree,
graduation, any graduation,
bachelor in or bachelor of dental surgery examination.
That is BVSC,
BDS.
That is BDS. Therefore, 70% from the exams under notification. First, next paragraph. 6 students complained as to faulty answers, key answers, and therefore an expert committee was constituted by OPSC. First up, committee gave report on 5/11/2018. 5/10/2018. Altering 14 of 200 answers. Questions it is, or answers. Key answers. 14 of 200 key answers. First up, there was a direction by coordinate bench.
No, man, single judge.
By a single judge in WPC.
WPC OSC number 2542 of 2018.
Decided on
15/11/21.
For undertaking a re-valuation of the papers in a wholesale way. First up, that was done on. Anyway,
That's only one here.
Yeah.
Date of examination, Your Lordship perhaps mentioned it high paid. It is
6/5/2018. 5/8 is 9/8 is result.
Yes.
Correct.
Yes. This Honorable Single Judge direction is at page 94.
Anyway, just for our purpose, for our consumption, because we have
only for the candidates, not for all. That is the crux.
But they did for all of them. No, I'm asking you.
Page 94. Only accordingly we direct the commission shall open the report of the expert committee.
Single judge directed to act upon the report of the committee in respect of the petitioner alone. Did he say not for others?
No, that accordingly it is directed that the commission shall open the report of the expert committee and consider the candidature of the petitioners along with similarly situated candidates.
Therefore, in a wholesale way.
Yes.
Similarly circumstances, it cannot be done selectively. Sectarian approach cannot be.
Similarly situated candidates.
Last sentence you did it. For all candidates it is.
Similarly, in terms of the said report submitted by the expert committee and communicate the result thereof to the petitioner within a period of 2 months. Hence, the petitioner as well as other candidate who had made a representation to the commission, being dissatisfied with the evaluation of their answer script, are found suitable for appointment. Necessary recommendation are to be made to the state government for their appointment. Out of 6 candidates.
Page number?
Page number 94.
94. That single judge cannot say when he has said for all of them you undertake. He cannot say the next part.
Yes.
It has to be understood in that light.
Yes, ma'am.
Page 93.
94.
94.
Relevant
sit and answer. Sit down and answer. No issue. This is not a primary school. We are all equal partners. Yes. Only thing is be kind to us because we are doing your job. Of course, not for free. We are doing our job also. We are doing your job. Yes. All right. Then, but now the entire select list will undergo change.
Yes, ma'am. And when the select list changed, what transpired?
Cut-off date also will change.
Yes, ma'am. What transpired was 8 persons who had been appointed under the first list.
Already appointment was done.
Yes, ma'am. 8 persons who were appointed under the first list did not find place in the second list. And 8 persons who were in the second list and had cleared the cutoff, they had not been granted appointment. So, OPSC took a decision. They advised the government that since appointments have already been granted in respect of the 8 people who were in the first list, they may not be disturbed. However, those 8 other persons who are coming into the new list after the revision of the list, these people may be granted appointment against prospective vacancies.
Once again, after the revaluation, 8 persons who were in the first select list and were appointed pursuant thereto did not figure in the list done consequent to revaluation. Semicolon. Other 8 persons who were not in the first list figured in the second list. So, therefore, the OPSC told the government to do what? Not to disturb the appointments of these 8 persons
already made.
That you said. White letter dated?
White letter dated 4th of November 2022.
Yes. Then what happened?
Then we further said that 8 persons who were not there in the first list, who have not been appointed.
No, we are there in the second.
Yes, ma'am. But they are deserving candidates. They may be granted appointment as and when vacancies appear. Vacancies come up.
In respect of the 8 now figuring in the second list, appointment orders be issued
against prospective vacancies.
Vacancy. Existing vacancies or accrual of vacancies?
Against prospective vacancies.
Future vacancy.
Against future vacancies.
These 8 include one Dr. Suman Tripathi, who was the lead petitioner before the learned single judge.
Petition.
Yes, ma'am. The respondents presently were also co-petitioners. However, they are not in the top 8. They are slightly below them. They are in 11-12.
In the second list.
In the second list. So therefore, they are beyond the cutoff marks as per the second list.
There is some missing of the fact. Pursuant to the Honorable Single Judge direction, the OPSC replied us. That is at page 95 of the brief.
What it says?
It says, we examined all the answer script as per the expert committee report and we found nobody received the mark above the cutoff mark, previous cutoff mark. Therefore, their cases has been rejected. Your Lordship, page 96 of the brief. In view of the above-mentioned facts, circumstances of the case, this commission has decided, since the above-mentioned 6 candidates have secured less mark than cutoff mark. Your Lordship, in the first paragraph, page 96, in pursuance to the order dated 15/11/2021, order dated 20.
Therefore, they cannot be recommended.
This order has been withdrawn. This order has been withdrawn. After a contempt petition was filed by the respondents, this order was withdrawn.
You state the fact. You state all the facts. This has not been communicated to us.
May I take your Lordship through the documents one by one from my convenience compilation?
This is a material fact. I have this.
That you have said that.
And
you have said it.
Thereafter, we filed a contempt petition.
All right. Let him argue. He's paid by his client. Yes.
Let's kindly have page 38 of my convenience compilation. One additional affidavit I will show you.
What is the gist of your submission?
Well, the gist of my submissions is...
No, what the learned single judge says? It was in their petitions.
Yes.
What the learned single judge says?
As the learned single judge holds, the judgment starts at page 1.
You could not have altered. No, they stopped there.
The learned single judge says
cutoff marks could not have been altered.
Could not have been altered. Well, it's the learned single judge failed to appreciate. Well, there are 2 concepts. One is the concept of a minimum qualifying mark, which is like a pass mark. In our 12th board exams, pass mark was 40%. In this case, it was 50%. That is already there in the advertisement. That is the minimum qualifying mark, which the Honorable Apex Court has said cannot be altered by the Commission. We have not altered that. The second concept is the concept of a cutoff mark. The cutoff mark is the mark secured by the last selected candidate. There are 121 posts.
Candidates are more, posts are lesser. Only
Yes.
then this question arises.
Yes, candidates are in the thousands, my lord. 121 posts. Their names are arranged in the merit list in descending order of marks. And when I reach 121, I will draw a line. This is the end. This is the cutoff. And the mark secured by that last person is the cutoff mark. Now, when the answer key was revised, then the marks
that also automatically gets changed.
Everything changes. And in fact, if your lordships have page 31 of my convenience compilation, I will show your lordships that even inter se selected candidates, they have also gone up and down.
No, that naturally happens because of revaluation in the third position. Because 14 questions, answers to 14 questions were altered.
Yes, ma'am.
The assessment was altered.
Therefore, the cutoff marks changed from 189 to 192.
It got enhanced.
It got enhanced. The respondents here have not cleared the first cutoff mark, 189. Therefore, their name did not find place in the first list. They have not secured 192.
In the
second, therefore, their names don't appear in the second list. Only Dr. Suman Tripathi qualified and she was granted appointment.
How many? There were 8.
There were 8 people who were.
Them one is given appointment.
3 have already been given appointed, and what I've learned is that all of them have been given appointment.
No, all of them have been given appointment.
Yes, Malaz. The state will be able to confirm, but
then what remains in the matter? What remains in the matter?
But the respondents here now claim that since 8 people in the first list who had secured less marks, they have been given appointment, I have to be granted parity. That is a negative equality that they are claiming today.
All of them already been appointed.
Already appointment.
By virtue of the interim order passed by the Honorable Single Judge, 2 posts has been kept reserved for the petitioner, for the respondents. And there is, to that effect, there is a order passed by the Honorable Single Judge. And here, my learned friend is concealing some fact. I will point out from there.
Please.
My lord,
he has not said.
My lord,
you may say he has not said certain facts. Don't say.
My learned friend is saying 8 candidates securing less mark than the petitioner have been selected. And continuing. They have filed the affidavit before this honorable court. The chairman, the secretary was called upon to this honorable court passed a specific order. How many posts has been filled up and who are the person who have filled up? What is the post lying vacant? You give an affidavit and tell specifically below the person who has appointed, how many persons securing more marks have not been given appointment. A specific affidavit has been filed by the OPSC that if we'll take all the candidates, then 43 candidates, those who have secured more marks than the last candidate, have not been given appointment.
First valuation or second valuation?
Second evaluation. And 11 candidates securing less mark than the respondent number 1 have been given appointment. My learned friend is asking for 8. That affidavit itself is contradictory. I can show the document.
Where is there? We'll come to you. We'll come to you. You reserve that point for your rescue.
Yes.
My lords, may kindly have page 12 of my convenience compilation.
We'll come to that. Is it true that your client had filed an affidavit?
No, my lords. What the petition respondents are attempting to do is to use the cutoff marks of the first list as against the marks secured by them under the second list.
That may not be correct, but if it is true,
the
fact affidavit is that fact.
What has happened now is
your affidavit.
I'm so sorry, Malaz. 8 persons who were appointed in the first list, they were not deserving as per the second list.
So you told the government, for those who have already been issued appointment orders, save them.
We said do not disturb them.
Don't disturb them.
Yes, sir.
Those who have come to the second list, though they did not figure in the first, you give appointment in the future vacancy.
Because they are meritorious.
To use words of our Mr. G.
Because they are meritorious.
Future vacancy.
Yes, ma'am.
Yes. Because vacancies were not there.
Yes, ma'am. Now,
vacancies were not there?
That's because all vacancies were filled up, Malaz. In fact, we have...
On the basis of the first list itself?
Yes, Malaz. In fact, after the new 8 were added, we have already granted appointment to more number of persons than what is permitted under the advertisement. We have granted appointment, we have said appoint 121.
When appointment orders were issued? Whether after the order of the court, single judge, or before?
Before the single judge order comes in 2021, my lords. They were already appointed since 2018.
In 2018? When you had constituted the expert committee?
5th of October 2018.
5/10/2018. And you were the appointment on you had sent the select list to the government on which date?
The select list was published on 9th of August 2018.
No, on 5/10/2018. You had appointed, the committee gave the report perhaps.
Yes, ma'am.
Committee gave
Committee
the
gave
report.
it.
You constituted, therefore I asked, on which date you constituted the committee?
The second committee was constituted on 5th.
Which second committee?
There is a
Expert committee.
Yes, ma'am.
Was constituted by you without court orders according to you.
Yes, after we received representation. Because the date of the report is report of this.
That makes no sense because we want to test your bona fide. Whether your client acted like a dalal or your client acted as a limb of a welfare state. That we have to look into because it is writ jurisdiction.
May I answer this? 9th of August, the examination results were published. The list of candidates were published.
Select list was prepared.
Answer keys were published on 20th of August. After the select list was already published. That is there in my list of dates.
No, maybe your list might. We understand the logic. It is like taking the Mangala Sutra to the damsel, girl, bride, after some events. The purpose of providing the key answer is what?
It's for the candidate to self-evaluate.
Self-evaluate. Then based upon complaint, you constituted the committee. You are not telling the date on which the committee was constituted.
That I do not have that date.
Perhaps your client has not given you. You here, arguably, you can use the word, the OPSC has not revealed certain things. The date on which the committee was constituted, the order by which the committee, because it is important. It is to know when you have taken the decision to constitute the committee.
It has been constituted after the publication of the results and the answer key.
Before the appointments. We want to know, you had after constituting, not even constituted, after you received the complaint from the aggrieved candidates, you should have halted the process because you wanted to take a decision on that. And you had taken one. On which date it was taken? If the complaints were given, representations were given, why at all you sent the select list for operation by the recruitment agents, recruiting agents state?
Yes, please.
That itself is false. They gave a complaint saying that there is something wrong with this. First point is, you gave the key answers after the select list was prepared.
Well, that is, in fact, that is standard industry practice followed by all the public service commissions, including the Union Public Service Commission.
After the select list is prepared?
Yes, ma'am. No application. In fact,
OPSC before final list is prepared, I can understand. But then what is the purpose of giving that?
As I understand your lordship's concern. I mean, I accept your lordship's logic.
Justice Ravindran.
I accept your lordship's logic.
Ravindran of Karnataka. But on the identical question.
On the ground of privacy, it is being published generally after and in fact, in those times, it was never published. Only after directions from this Honorable Court, we published the answer key. On 20th of August, the answer key was published.
And 20th August?
Yes, ma'am.
But you sent the key answers were published on 20 August 2018, pursuant to a learned single judge's order dated.
There is a tribunal order, minutes.
Tribunal's order, it is order dated
17th July 2018.
17/7/2018 in OA number, there are
OA number 1790 of 2018.
1790 of 2018. Who were the applicants?
The respondents were there.
These were.
Yes, sir.
Filed by respondents hearing.
Along with order dated 6th of August 2018 of this Honorable Court. This was 6th of August 2018.
What is that order?
Well, this Honorable Court also directed that the answer key may be published.
How WP came to this court when tribunal had jurisdiction?
May I clarify? The present respondent number 1 filed a way before the tribunal to publish the key answer. The tribunal rejected this.
That came to
against
WP.
Against that.
It was by DB.
Yes.
Division bench.
Yes, division bench. Honorable Chief Justice Javeri and Justice K.R. Mahapatra in WPC number 13249 of 2018 passed an order on 6/8/2018.
In WPC. In WPC number?
WPC number 13249 of 2018.
Disposed of on
6/8/2018.
A direction was issued
to OPSC
for providing the key answers.
This order was passed in presence of the OPSC Council. This order passed on 6/8. On 9/8, they recommended the name of 168 without publishing the key answer. Your Lordship may smell something here. The OPSC Council.
When did you send a list to the government?
On 9th of August, man.
When 6/8 the order was there.
6/8 the order was there, man.
To furnish list.
Yes, man. To furnish the answer. And we have furnished it on, the direction was to supply the answer key and marks to the respondent number 1.
Correct.
And we have supplied it, man. So on 20th of August, we supplied it.
Correct. Why did you send the list of candidates for appointment?
Because there was no bar balance.
Means? How, brother? What for this list? The answer keys? What for it is?
Malice, I understand, Malice, but
it is not a lollipop to given to the children. You will give that key answer so that the stakeholders who appeared in the examination will evaluate, make their own valuation. Whether what valuation your people have done is right, wrong.
Well, it's even today, in 2026, the procedure that is followed by OPSC in several cases that we've seen. Nowadays, an examination is held. After the examination, 7 days is granted to the candidates to provide their objections. We don't publish the answer key then.
No, unless you provide the answer key.
Well, we don't. It is only after results are published, the names are selected, thereafter we publish the final key list, answer key.
Absolutely.
It is, even today that is done, man.
It is absolutely false. Because counsel for the OPSC, this statement is not expected. Now, in fact, before publishing the result, they are publishing the key answer. Even if somebody has some objection, they are filing their objection. They are also considering. Thereafter, the result is published. This is the procedure adopted by the.
That's how, at least in one or two judgments of the apex court, it is said that way.
And this question was particularly passed by the previous occasion by this division bench to the secretary who was personally present in the court. And the court expressed their displeasure. You are a secretary of the commission, you do not know what is the procedure, that is the order sheet, from a order sheet you are eligible for.
Ultimately, Malaj, nobody is, the respondent relies on the expert committee report dated 5th of October 2018. The respondent does not raise any ill intention or malefied on the preparation of the report dated 5th of October 2018. In fact, the cause of action for filing the writ petition before the learned single judge was the expert committee report 5th of October 2018, which helps the respondent. Therefore, Dr. Suman Tripathi and the respondents
are appointed.
They came before the learned single judge. One person succeeded while the others failed. Therefore, there is no question of malafide on the ground by the OPSC.
Not malafide, legal malafide. Factual malafide, legal malice. Legal bona fide is there.
I must tender my apology that this case arises out of mistakes committed by the OPSC experts. Had the mistake not taken place in the first place, in the answer keys, this litigation would never have arisen. Mistakes were made in the first list. Therefore, the answer key was revised. After revision of the answer key, a fresh cutoff mark of 192 was fixed. And 121 persons as per that list, where the OPSC said 113 have already been appointed, 8 persons may be considered for future vacancies.
But they will lose the seniority is their grievance.
No, Malins. These respondents do not come in that 8.
No.
Even as per the new list,
the second list.
Even as per the second list, the respondents don't qualify.
No, but you said to the government that already you have issued appointment orders to them and you rescue them.
We said do not disturb that because nobody, even in this case, there is no prayer that those candidates be removed. They have not even been implemented as parties. In order to avoid multiplicity of litigation, because those persons had already been appointed, we told the government don't disturb them. As per future vacancies, you appoint 8 others.
No,
the respondents.
That gives doubt as to it's a constitutional body. They are members of the constitutional body. Therefore, much we are not speaking. We don't say any vyapar has taken place. We will not say that. Because see how the things have been accomplished. It only reminds me of what Shakespeare said in a particular poem.
Well, may I show your lordships the 2 select lists? Your lordships will be clear after seeing the select list.
No, we have understood what is already there. What we do not understand is, what is the focal point of a jurisdiction? My professor,
it's a violation of fundamental rights.
No, wrong. My professor, K.N. Sheshadri, said in my second year, the focus of writ jurisdiction is the process, not the product. He is not there. He is not there. He was very brutally murdered. This is another thing. But what he taught us, that remains as a fundamental, which I will carry to my grave. The focal point of the judicial review is the process. How a public authority does, it undertakes, and not the product. See the process. How
I will demonstrate the process.
No, what demonstrated? You have demonstrated already. Question is, one set of people went to KAP. Another person, 2 persons went and they lost. Then they came to division bench. Division bench said, furnish the key answers.
Yes.
And you furnished.
Yes.
Then they filed objections.
Yes.
6 persons filed objections.
Yes.
You constituted a committee. When they filed the objections, once there was an order by the High Court, division bench, you should have not touched that file. Because whole exercise has to be undertaken, we know, based upon the result, the recommendation of the expert committee. That is the object. There was some haste, something I do not know why. We do not cast aspersions on the members of the constituent body, constitutional body. But things are, people are wise nowadays. They will assume what might have happened.
Plus, the order of this Honorable Court dated 6th August 2018 is not on record. However,
there is an order.
The order said that the petitioner that the OPSC will supply the answer key and the marks secured by the respondent number 1.
Correct.
So it was an in personam order.
Then why did you constitute the committee?
But the committee was constituted later on.
Correct. But that will cast a shadow on what all has happened earlier.
The first list. Definitely errors are there in the first list.
Who sent the list? Who is that person? We will take action against him.
Secretary.
Secretary?
Well, it's the then secretary.
Is he in service?
2018, my lords.
Is he in service?
Well, let's verify, my lords.
Is personally he appeared twice before this honorable court?
No. That same, well, secretaries have been changing from time to time.
Mr. Roy
He
was the
was there.
secretary. Mr. Roy, my lord friend was not the counsel initially. My lord, writ appeal was filed by Mr. Tripathi. It has been subsequently transferred to my lord friend. And the original writ petition was argued by Mr. P.K. Mahathi. They have changed the laws frequently. Senior advocate Mr. P.K. Mahathi. Mr. Roy was personally appeared before this honorable court.
Is he IAS officer?
No.
Generally, they're OS officers.
Generally, they
IAS officer.
Yes, ma'am. Your lordship will wait from the order.
Doubt is arising. A thick doubt is arising in the mind of constitutional court as to how the secretary could send the list of members.
Well, may I place the order dated 6th of August on record, Mel?
We will take it now. What is that? There need not be so much circus for that. This is it, court. It can take anything.
Yes, ma'am.
We are asking you. We want to decide. This is not the way. See, everybody is watching now. Everybody understands how things are accomplished in various branches of the government, how recruitment process is undertaken. Everybody understands nowadays.
Well,
even in Cuttack market, if you go, they will tell you, sir, things are, but don't reveal that you are a lawyer or a judge. Just go and purchase some vegetable, fruit, or the bangda fish, which is prop fish. They will tell you, sir, it is not like that. Something has happened. The kind of legal mischief, when so much has happened, immediately he sends the list. We don't say there was vyavahar, etc. We will not say that. But people understand. People understand. We need names of those secretaries.
Very well, ma'am.
We need names of secretaries. Now they are working. We may summon them. We may issue notice to them to come here and answer why the list was sent when division bench said, furnished, you furnish the key answers. Maybe one candidate. That itself may vary, the list itself. The first person may become second, last person will go out because of addition, possible addition.
Right.
That is the object.
As on date, the Odisha Public Service Commission is not taking any stand to protect those 8 persons who were not deserving who were there in the first list but not deserving as per the second list.
No, that again is another.
That it's the commission.
2018. What is the duration of the members of the commission? 5 years?
5 years, ma'am.
Now new members have.
Secretary is permanent.
New members have.
Secretary.
Permanent means he may continue.
He may continue. Secretary is not a.
No, it's a deployment from the government. And they are not parties.
Secretary.
No, appointees. What I should do with the secretary? Appointees are not parties.
No, appointees.
Therefore, we cannot do anything to them.
We have no claim against the appointees. We're absolutely saying we have no claim.
But if you are given seniority,
seniority, the Honorable Single Judge has directed.
The respondents have not been appointed.
They have been illegally.
Respondents have no claim for appointment.
No appointment is issued.
Yes.
No, respondents have no claim for appointment.
Yes, we only for appointment which has been allowed by the Honorable Single Judge.
Well, it is against that order that we have come in writ appeal to address the question of law that the OPSC does not fix the cutoff marks. It is a function of the answer key.
No, but it will not be. See, you are in a certiorari jurisdiction.
Yes, madam.
So in a certiorari jurisdiction, the proceedings are not confined to the questions you raise.
Absolutely, my lord.
Object of certiorari is to look into entire record, find out where the defect arises.
Absolutely, my lord. I bow down, my lord. My lord, my only submission is, my lord, I bow down to your lordship's jurisdiction, my lord. My only submission is that I am only demonstrating that the respondents here do not have any claim. Because they have not cleared the first cutoff, they have not cleared the second cutoff. They are not part of the 8 persons who were there in the new list who we thought were deserving. One of the co-petitioners, Dr. Suman Tripathi, was deserving and she has been granted appointment.
Other persons are not given, but you have recommended.
Three were already appointed as on 4/11/2022. Five, in respect of 5, OPSC said government may consider their appointment on prospective vacancies. So when 3 were appointed.
Any vacancies have arisen?
Yes, my lord.
Yes,
there is an advertisement recently published.
No, I'm asking, any vacancies have arisen? Answer is yes or no.
Yes.
Then we can explain.
Yes.
Is it? When binary answers are sufficient, we need not do a big thesis on that. How many vacancies have arisen? How many you have notified thereafter? You only having recommended.
Yes, my lord.
For their appointment.
Not for the respondents, my lord. Not for the respondents. Respondents have not been recommended for appointment.
On what basis learned single judge says? You say in the first list they figured. Then on the basis of revaluation, another list was prepared.
Yes.
In that they did not.
Yes, ma'am. Now, let me just show the list. It will be clear because I have shaded the names of the persons who come out, who come in.
You said that, na? 8 will come out, 6 will go, 8 will go.
8 will come out, 8 will come in.
8 will come in.
Now, 8 coming out, we said that because they are not parties into any litigation, it will give rise to litigation. Don't disturb their appointment. In respect of 8 people coming in, the respondents are not in that 8. They are in serial number 1112.
Let us see on what reasoning learned single judge says.
Yes, ma'am.
The cutoff marks could not have been altered.
Your lordships may kindly have page 200. The judgment starts at page 171 and the relevant starts at 200. It's 206 minutes.
Go to 171. Okay.
Is corporate.
The judgment starts at 171 minutes.
The 23 to 2024.
Yes, madam.
Service.
23 to 24 minutes.
Which paragraph, brother?
Now let's may kindly have para 46. On a query, your lordships have para 46.
Yes, on a query.
On a query being put to the learned senior counsel appearing for the OPSC by this court, learned senior counsel appearing for the OPSC submitted that cutoff mark has been revised on the basis of the suggestion given by the expert committee set up by the OPSC. No further explanation is coming forth from the side of the OPSC to justify the revision of the cutoff marks. After conclusion of the entire recruitment process, in the aforesaid background, this court is of the considered view that the OPSC should not have revised the cutoff mark from 189.558 to 192.558. Further, this court feels that the OPSC, after re-evaluation of the petitioners and similarly placed other persons' answer scripts, should have applied the revised cutoff fixed earlier.
But is that revised cutoff fixed earlier means what?
Well, it refers to the first cutoff.
No.
I think, well, there may be a
revised cutoff mark fixed earlier. How can that be?
Well, it's our
cutoff mark fixed earlier to revision.
Well, I believe there is, because it's there is a double negative. It's a double negative. Well, I believe it refers to the first cutoff mark, which is 189.558. So the learned single judge says you revise the marks of the candidates, but you apply the old cutoff.
No, that may not be correct.
That is what we have challenged, Mills. They say This court feels, in the aforesaid background, this court is of the considered view that the OPSC should not have revised the cutoff mark from 189.558 to 192.558. My first submission is OPSC does not revise the cutoff mark. It is a function of the answer key and the number of vacancies.
It is a concomitant result of exercise of revaluation.
Yes, ma'am. It is contingent on the marks on the performance of candidates.
Valuation.
Then they say, further, this court feels that OPSC, after revaluation of the petitioners and similarly placed other person's answer script, should have applied the revised cutoff mark fixed earlier, and on such basis, the case of the petitioners and other similar persons should have been assessed. This is more so in view of the well-settled proposition that the rules of the game cannot be changed.
Cutoff is not a rule of game.
I bow down.
Cutoff marks cannot be construed as a rule of game at all. But yes, so many problems here now.
Your lordships have on earlier occasions summoned the secretary of the commission to explain this this case is a conundrum. Absolutely. There's so many errors have been committed by the commission. I apologize on behalf of the commission. But my only submission is that the respondents do not qualify. And the question of law.
The problem is, all this has been done and they are not parties. Now, if we tell to do the things on the basis of the new list, then that will open up Pandora's box.
Whereas the new list we have already implemented by directing that 8 persons be granted appointment. 3 have already been appointed.
Your clients have been now once slowly.
Yes.
Kindly,
Yes,
slow and be kind.
I am comfortable with.
Otherwise, you may suffer an order at our hands. Really. If now so many things have happened, case is also not properly conducted, whatever it be. Those who are already appointed, we cannot upset their apple cart.
Absolutely right. I have no issue.
No issue. Now, if there are vacancies and if your clients are accommodated, will you be happy?
That is the order. That is the order part by the single judge. That is the.
Maybe reasoning are different. Yes, you answer.
Maybe the
you answer.
Because you say appoint them to the prospective vacancies.
Well, it's not the respondent.
Not the respondent.
8 persons. 8 different persons, of whom 3 have been done. 3 have already been.
Your lordship.
Respondent is not in the
same selection process. 11 candidates, their affidavit, securing less mark than us, they are continuing, will not get the employment.
Well, it's made.
I am posting I am defending some candidates. I am putting a question. Selection process. And the cut-off theory is
less meritorious are appointed, more meritorious are left over.
And the cut-off theory is propounded by them. The Honorable Judge, Your Lordship, paragraph 45, the Honorable Single, only 1 second. The Honorable Single Judge asked the counsel who was appearing before the Honorable Single Judge, 2 persons securing less mark than the
counsel.
Yes, ma'am.
In the second list, those who have secured less marks than the respondent,
yes,
have they been given appointment?
No, my lord. They have not been.
My lord, they have filed the affidavit. I will show the affidavit.
Show that.
First affidavit.
Yes.
To Bhattap.
Only, with the caveat, my lords, 8 persons who were there in the first list, not disturbed.
Means they will secure less mark.
They secured less mark.
Than the respondent.
Yes.
My lord,
therefore he is doing like that.
Therefore, there is what, therefore the claim is one of negative equality.
No. Merit is the mantra. Because these are unreserved category.
Yes.
In unreserved category, merit is the mantra.
Yes. Yes.
If persons who have secured less number of marks are given appointment, whether in the first list or second list, those who have secured more marks in the second list, how can you deny recruitment? What heartburn?
I'll answer it. In the first list, 8 persons were not deserving.
That you have. In the second list, they became deserving and we recommend.
No, my lords. These are 8 different persons. 8 in the first list.
Say all that I do not understand. If they are more meritorious, his case is that.
Yes.
If my clients are more meritorious, how can we be prevented from gaining entry to public employment? When less meritorious candidates have occupied the seats.
Well, they have
simple.
Well, the reason why I say it's a negative equality is because the right is based on an error committed by the OPs.
Correct.
8 persons who were not deserving were granted appointment
because you recommended.
We recommended, yes. We erroneously recommended.
No, that you cannot say. His client should suffer.
No, because
more meritorious candidates. What is the object of a public recruitment process? To choose best from the market.
Well, when the initial appointments were bad in respect of 8 persons are bad in law, what the respondent seeks is parity with that, with an error committed.
Your error.
My error, my lords. I bow down, my lords. My error. But it is a negative equality that is
whatever name you put it, you call it half a dozen, 6, that is not bothered. What he says is, what is sin of my clients? Well, it's more meritorious, they don't get applied.
May I just take
may I
take your lordships to one page? I have to show your lordships one chart that was prepared in an affidavit.
Yes.
Page 42 of my convenience compilation.
Before that, only 1 second, your lordship.
Well, let me finish this minute. Let me finish my submissions.
The secretary, now they are confining 8 candidates. The secretary filed an affidavit and produced the document before this honorable court at Annexure E, Tag E, 11 candidates securing less mark than the petitioner, they are continuing in service.
That's what we are asking him.
11.
Malice, let me. May I show your lordships page 11. Malice, may I show your lordships
in an affidavit before single judge.
But
yes.
you have not implemented them as respondents.
I have not implemented.
Malice, may I show your lordships page 42? There is a chart. Page 42 of my convenience compilation.
42.
Yes, Malice. The brief was so bulky, Malice, I prepared this compilation for my
we have
convenience.
understood the case now. We have understood something beyond the case also.
I was appointed as counsel in this matter just last year, Malice.
All the best. You become Attorney General, we will be very happy. But how we should interfere in this matter? Regardless of 2 things. Learned single judge has logically erred, legally erred is no ground for appeal. You have to show why the order is unsustainable.
Yes.
That you can show only by demonstrating that it has brought in an unjust result.
Malice. May I show you page 42, that chart, Malice?
We saw 1 to 6.
Yes. Now, serial number 3, your lordship may first see Dr. Suman Tripathi.
You said the appointment.
Yes. Well, let me show why. Cutoff mark as per expert committee A. That was the old cutoff mark.
The 192 point, that is...
No, 188.366. Serial number 3, Dr. Suman Tripathi.
No, next point, second one. You are going for the first one.
Well, as I'm showing your lordship, serial number 3, Dr. Suman Tripathi. Cutoff mark as per the expert committee A. Your female is 188.366.
Yes.
She had secured 186.376. I will stop here. She was not granted appointment in the first phase. Then, my lords, after the revision of the cutoff mark happened, the cutoff mark changed to 192.423. She secured 197.376. She was granted appointment. Now, your lordships may see serial number 1, the respondent. Cutoff mark was 189.558. He had secured 184.210, not granted appointment. After revision, cutoff mark is 192.558. He secures 191.210, not appointed.
This judgment is what?
But this is an affidavit that we had filed.
That's your affidavit.
Yes, Manoj. These are the marks secured by, these are the undisputed marks secured by the candidate.
Very most welcome. But you have to satisfy to us that you have adopted the merit mantra. That you have not adopted. less meritorious are given appointment.
Yes.
More meritorious are not given appointment.
They have been
And
appointed.
learned single judge's order does justice. You do like this. Maybe reasoning part will vary. What I say, my brother may not agree. My brother may agree with the final result, but I may not agree with the reasoning of my brother. If we arrive at a particular result, why at all we should interfere? Now this order has brought about a just result. How you are agreed?
Well, it's because we are aggrieved with the question of law, Malis.
What question?
Because cut-off marks.
We'll decide it in an appropriate case, not in this case.
Malis.
That reasoning, perhaps arguably, it is.
My only difficulty is this, Malis. There were 121 posts. 5 were reserved by virtue of interim order.
Now new vacancies have arisen.
Yes.
New vacancies are, although you did not recommend their case.
Yes.
Still they are more meritorious than the candidates who are already appointed. We are repeating again.
Yes.
Let them get a job.
Malis, there are 2 respondents who are before your lordships. Now, Malis, there are 43 other fence sitters.
We do not know. No. Because of your action, all this has happened.
Malis, I bow down, Malis. But since your lordships have time and again said that appointments cannot be made over and beyond the number of advertised vacancies.
No, but that contention is not open to you because you only had recommended in respect of others.
But
in respect of others, you said keep future vacancies for these people, not these people, but other people. But that comes in the way. You cannot change your colors depending upon who the respondent is. Your OPSC cannot act like a chameleon.
In an ideal,
go on changing the colors depending upon.
In an ideal scenario, these 8 persons would have been removed from service. But since they were not paid parties, anyway.
That's all right. It is your mistake. All of a sudden, you sent the select list to the government. Why you sent it? It gives us a wide imagination. It will give us a wide imagination. Maybe that some deal has happened between whom we do not know. It gives an impression something has happened. All this is going on. There was no reason for the secretary to send the list when process is on. We will make caustic remarks against the secretary. Who is that person? Where is he now?
I do not know, my lord.
You have to give that this one, no? Otherwise, things will go on like this only. Everything will be auctioned.
One affidavit.
So what about the people?
One affidavit was filed by the opposite party number 2 in compliance to your lordship's order dated 25/11/2024.
The last candidate, as per the revised list, who was appointed, he has secured 184.
Less than your claims.
184.934.
Yes, less than
his claims.
Less than
Therefore, rightly or wrongly, a learned single judge, maybe little wrong reasoning, he has brought about a just result. If just result is brought about, then that result will not interfere.
Your lordship, my only submission is that this is a negative equality.
We want not only just one case. We want to know why secretary sent all this
names to the government.
And why government accepted it. Whether government works blindfoldedly.
Once the
something
matter is recruited by the matter is self-recruited by the my lord. Matter when the matter was selected by the
how government could act
selecting agency, my lord, the government has given appointment simultaneously. Affidavit was filed.
Government was a party before the division bench.
Before the single bench.
Single bench.
My lord.
It is a constitutional fault.
Obviously, man.
Government is a party.
Yes.
There is a direction to undertake the issuance of the key answers.
Yes.
Key answers accordingly you gave. Thereafter, candidates, means they gave. Thereafter, candidates made representation that everything you have to do.
Lord, in the affidavit,
the committee.
My lord, in the affidavit, my lord, they have clarified it certain. Paragraph 5, I am placing page 8
of
the affidavit which was filed by the opposite party number 2 in compliance to 25/11/2024.
What to that?
It is not there. Date would be paki.
कौन सी जगह है signature नहीं date
Date nahi. That is, I'm sorry for that.
Black peak.
My lord, lordship, page 5, paragraph 5, your lordship may kindly see. Subsequently, Secretary OPSC White letter dated 4/11/2022 intimated that in compliance to order number 1 dated 22/4/2022 of the Honorable High Court in contempt number so and so and WPC number 2542 of 2018 filed by Dr. Suman Tripathi, the merit list of dental surgeon was revised based on the expert committee report dated 5/10/2018. In the revised merit list, OPSC communicated the name of another 8 candidates who were not selected in the earlier merit list have been found selected and submitted that no action need be taken at this stage. They should represent in future. The government may consider their appointment on prospective vacancies. 8 candidates as follows.
They are given appointment order various dates.
My lord, accordingly, out of 8 candidates on recommendation of OPSC, 7 candidates have been given appointment. But
one candidate, Anshuman Raut, in category of UR, has not been given appointment as representation from
my lord. He has not been received.
Copy of OPSC letters.
That is what I want to draw your lordship's kind notice.
No, we would have passed the order right now, but we want to see that secretary. We will not so easily leave anybody doing like this.
Lord, the counsel for the OPSC may submit the name of that OPSC.
I'll find out.
So that
we'll call it tomorrow.
Yes. Let's speak tomorrow. Very well.
Because we want to issue notice to him.
Yes.
As to why he did all this.
Very well.
We may spoil his service records. But we can't do it without hearing him. Suppose if he has a justification, then we have to change our mind.
Very well. It's tomorrow.
Can you keep him present before the court?
He can.
Oh, how? If that secretary is not.
Yes, he will now. No, he will now be an officer of the government.
What is his name?
It's 2018.
He has to explain all this to us now.
Satyabrata Rai.
No, Satyabrata Rai is the present
secretary.
He's the
present.
He was secretary in charge last year.
You ask. You go and tell
I'll
him.
give
You
a
can
phone
call
call.
from here only.
Yes.
Call from here only. Call your client secretary. Ask him who are the secretary at that time. It cannot go that way. They should have sleepless nights. They should have sleepless nights. Their kidneys, lungs, and heart should work more.
Sir, namaskar. No, Arnab Dehradun. सर गोटे केसेस कोर्ट जानिया चाहूँगी 9 अगस्त 2018 दिन ये सेक्रेटरी थिले.
Tell him court is asking and you are speaking over phone in front of the judges. Who was that one?
9 अगस्त 2018. Sir, incumbency chart will be behind him.
The board will be there in every PSC.
Umuda Chandra Malik.
Ask him to come here immediately. Ask him to come here.
Well, is the present secretary?
Yes.
Again, sir,
ask him to come here immediately.
Sir, court चाहूँचे आपण टिके आसिबे संगे संगे High Court को.
He should come running.
Sir, एबे संगे संगे. आगे sir डाकुचे आपण.
He should do all his job and come here.
ओडिया ना ओडिया कोर्ट चाहूँची बोली कहउछन कोर्ट चाहूँची जानिबा ले कहउची
आपण
एटा भाषा आसीबो
ନାଇଁ ସେ ଟିକେ ଓଡିଆ ଲାଙ୍ଗୁଏଜ ତାଙ୍କ
ପ୍ରୋବ୍ଲେମ ଅଛି
କାହିଁକିନା ମୋର ସେମିତି ହୁଏ ଘର ଆଗରେ ସେ ଯୋଉଟା
No, ask him to come immediately.
He is not
Leave everything there and let him come here.
Your Lordship, he is not intentional. Okay. But I can understand he is not intentional.
No, that is her time and again he is saying. No?
The way he conducts himself outside the court also, I can understand he never do.
ଆପଣ ଆସିଛନ୍ତି ଅଫିସରୁ?
That way he is very decent.
ମୁଁ କୋର୍ଟରେ ଅଛି ଆପଣ କୋର୍ଟର ଫାର୍ଷ୍ଟ ଫ୍ଲୋରକୁ ଆସିଯାନ୍ତୁ ମୁଁ ନେଇ ଆସିବି ଆପଣଙ୍କୁ ଆସନ୍ତୁ
Tell him court hall number.
ଆଜ୍ଞା କୋର୍ଟ ନମ୍ବର 25 କୁ ଆସିଯିବେ
Yes. And tell him if he does not come, something will happen.
ନାଇଁ ଯେମିତି ହେଲେ ଜଲ୍ଦି ଆସିବେ ଟିକେ
Yes.
Substandard. Spoiling the state administration.
Yes.
Because the present secretary was not in charge back then.
He will tell. There are some questions I have reserved for him. Yes, all. Pass over. Go to the next point. Next case.
Item 23.
Because I mean, I'm English. My
I could understand.
Well, he is not that way.
Said about that.
I'm an English medium school student, whereas my Odia is like.
No issue. At least you know Oriya. I am still learning. Yes.
Your Lordship was big.
And you can confer with him for a few minutes after he comes.
Yes, ma'am.
And what all we want. Now we have seen what we wanted in this matter. Ask all that information. And we just want to see him. Tomorrow we will see another, his predecessor. Yes.
But these cases,
if we do not do this officer's thing, today we will do this, nothing will happen tomorrow. It should come tomorrow. Then only accountability begins. I will not. Yes. Just one. Yes.
In fact, your Lordship was pleased to issue notice in this matter, and now the matter has come up. If your Lordship has ordered dated 3/7/2025, your Lordship indicated the reason why your Lordship is issuing notice.
When we are halfway through in a case, the same steno should sit here. Because he will be having what all we have said. You can ask him what you have written about that. Anyway, you tell him, maintain this discipline.
In fact, my friend appearing for the respondent was saying to the instructing counsel that he will be filing a reply. Though in a writ appeal, no reply would be necessary. I do not know whether he has filed or not. If
No,
not, your
that
Lordship
ground we are not giving unless you convince us. If that is your grant, we will not grant adjournment.
No, I am praying if your Lordship it was notice was issued. Now she has appeared. The content proceeding also was closed pursuant to your Lordship's.
Anyway, interim order is granted to you.
So
there
your
are many
Lordship,
older matters where no relief is granted to lawyers.
so your Lordship fix a date for hearing.
Let us call after 3 weeks. Interim order to continue. Next.
Item 25.
May I please, Your Lordship? The appellant is the writ petitioner. This is a matter related to compassionate appointment. His father was working in SBI as a messenger.
He died on?
He died, my lord, on 31st, 2005 due to cancer.
Cancer.
Cancer. 30th of January.
January
2005, 20 years ago. How many years of service he has put in?
17 years.
17 years.
My lord, he joined on 5 February 1988.
All right.
My lord, 30th.
His children, how many children? Widow.
Widow and 3 sons.
Who staked the claim for appointment?
The elder son.
Whether others had given consent?
Consent.
Why they rejected?
My lord, the matter happened like this. On 30 March 2005, the mother of the appellant, she made an application. Thereafter, what happened? Some third party lady, she came and she
I am
claimed
also
to
widow.
widow. And to bring that cloud out of the matter, there is a civil suit constituted, and that suit ended in 24th for 2013.
OS number?
Civil suit number,
PS number?
PS number 48 of 2011. CS.
PS number?
48 of 2011. Before the
Who had filed that suit?
that the mother filed the suit,
Mother?
a declaration that
Widow filed the suit.
Widow filed.
Only widow.
Only widow.
Whether she was a party, other side was a party.
No, other side was not.
Then what was
Because-
the declaration?
The declaration was that, my lord, that the mother is the
Few wife of deceased employee.
the nominee, sole nominee of the deceased husband. That was the specific.
How the nominee will help you?
My lord, thereafter there are admission by the bank in various occasions. In that suit also, there is deposition and there is admission by the bank that she is the wife of the deceased. That
Is it?
specific admission are there, and there are 4 or 5 occasions when
Bank was also party to the suit.
party to the suit.
What was
And
that?
the bank deputy manager, in his deposition, he has admitted that
She is the widow.
yes. Thereafter, my lord, what happened?
What is the decree?
Decree, my lord, it is on record. May I bring my lord's attention? It is, my lord, at page number
issues print.
Page number 30.
Then check to all deaths benefit, including the pride in the election, current the of decree.
Page number 31.
There is a factual mistake what my learned friend is saying.
Anyway, I have seen that.
Milord, what happened? The person who is claiming for the compassionate appointment, there was a competing claim from the other widow, and she is claiming.
How can you say that she is the widow of the deceased?
No, Milord, what I'm saying, there is a petition. The other person's son, means lady, has filed a petition saying a representation that I am also the wife of the deceased and give me appointment.
But no, point is not that. Many people will come from Katak market and say, he was my husband. You have given all terminal benefits to which lady?
Terminal benefits only as a nominee, Milord. What happened? She has filed a suit.
No, again wrong.
Milord.
Under your service rules,
Milord.
can third party other than the wife be nominated?
No, question, Milord, when appointment of compassionate is coming, even if a concubine's child is also eligible to get, so that when he has filed a petition, a representation before the bank saying I am also, because the wife is only nominee for the
terminal benefits.
Not all terminal benefits.
No, sir.
It is only-
In the service register, the employee has mentioned his client as what?
What was wife?
Then we have
That is admitted, Milord. Question is, when she has filed the petition for, but no claim of compassionate appointment was asked for. Only said the terminal benefit may be given. The terminal benefits, she was nominated for 2 things. One is, Milord, for SBI Life and Provident Fund. Then she filed a case for the succession certificate when we said that.
Question is all that you are only telling all this.
No, Milord.
Then answer.
Milord.
No, there is a parameter.
Milord.
A plethora of judgments are there.
Milord.
From that, what comes out is whether that lady is mentioned as the wife in your service register.
Milord.
Answer is yes.
The service record, the name of the petitioner was a wife. Petitioner's mother is there.
Correct.
So thereafter, only as a nominee there was there.
That is
to
all
claim,
right.
to claim.
There cannot be any other person than the wife as nominee.
No, Milord, there is a dispute that's
Who said you to decide dispute about
no, we have not decided. When representation come from another person saying,
all right, you should have said we
have rejected
in our record. You go to court, get appointed with the declaration that you are the widow of the deceased. Then
she went to, that is pending, Milord. She went to the court also.
Is there any interim order?
No interim order is.
Then why have you not given all these years?
No, Milord, he has not made an application in 2005. He has made an application in 2014. Then thereafter, the bank has communicated that you have given after when the appointment of compassionate is not in the scheme and paid.
It is clear from the impugned order, my lord.
When it was?
30th March 2005.
No.
Date for compassionate appointment. Application for compassionate appointment.
30th March 2005.
On the very day.
On the
30th March.
13-3.
30th March 2005.
Where is that document?
Copy.
My lord, it is very much present in the impugned order.
No, my lord, in the writ petition that was not there. In the rejoinder, there is a manufactured petition saying that he has made a claim, bank has not received, nothing is there. In only rejoinder he has given. But actual petition has been given 2014, and where he has referred in 19 also, in the same year, again he reminded that I have given an application 2014, give me the appointment. For after 10 years.
One sentence over. There should be some halt. On what ground you rejected?
We have rejected the policy is not there for compassionate appointment at that time. You can go for ex gratia payment. That was a communication made to he has made to the regional office, and the regional office communicated to the branch. Thereafter, all these competing claims has come. That is why the bank has not given anyone, because at that time there is no position of compassionate appointment. After 10 years, he has.
One sentence, no full stop or comma in your statement.
Milord, sorry.
They are not taught in your school.
No, Milord. Sorry.
Now,
Milord.
He died on 30 January 2005.
Milord.
As on that date, there was a scheme.
There was a scheme. At that time, there was a scheme.
Scheme came to be abolished when?
That has not been stated here.
That you have to state.
2005.
So I will, Milord, take instruction, because that is not here. Where actually the letter has stated that there is no scheme at that time. They said ex gratia payment. And
what is the ex gratia payment?
Ex gratia payment means certain amount is to be paid.
How much?
1 minute. Yeah. Your Lordship, Annex 4, it is stated, you may apply for branch manager B Udayagiri for consider for ex gratia. Please note that such application ex gratia payment will not be entertained after 30th September 2014. This is the letter communicated. This is the annexure 14. Milord, 2014. Because in 2014 he has given application first time to the bank. So bank has forwarded this as letter written by Assistant General Manager to Niranjan Panda, the applicant.
What are the particulars of that ex gratia scheme?
Scheme that it has not started.
Why you did not state?
Milord,
you are a bank.
Milord, that will be there, but question is because of competing claim, the bank has not given that. I go down, Milord.
There is no competing claim at all. Any vegetable vendor may come and say, I am the widow.
I go down, Milord. I will take instruction exactly.
On your records, there is a widow.
Widow.
On your records,
Milord,
there is a widow. To her, you have settled the terminal benefits on the ground that she happens to be nominee.
Only upon the court.
Widow is the nominee.
No, widow nominee for not all. He filed a case. Thereafter, bank settled. Yes.
Can it be she is wife for X purpose? She is not wife for Y purpose. Can you argue like
No, Milord, that I am not arguing. I brought on before Lordship to see that actually when he has filed in 14, there was no scheme and that has not been given, only said the ex gratia to be paid.
At least when you are saying, this is our ex gratia, at least to the writ court, you should have stood there and said that this is our ex gratia scheme. So much amount she will get, our children will get, they can apply like this. This is the format. Your state under Article 12. You have to be like a model litigant.
No. Only because of the competing claim. Your Lordship can come to single judge order. But your Lordship.
Competing, we don't agree.
The single judge.
Question of competing.
Service
records contain name of the widow.
Your Annexure 1. Annexure 1 is very clear. Pushpanjali Panda wife. Pushpanjali Panda wife. Share to be received is 100%. And you said that verified with our records and found to be correct.
That is there. Question of one pap.
That
person has come. When there was a competing claim, the another lady's son is saying that I am also the son. Wife may be null and void. As per the section 16 of Hindu Act, the wife married null and void. If somebody can come and say that I am also the son of a particular person, and then this
litigation rival claim was by whom? By widow and the children.
Yes, the wife, the second wife or concubine wife.
Kindly do not say second wife. The first widow may sue you for damages.
Mirror. The lady
You have created, your bank manager appears to have gone to a marriage of that lady as if he has sworn to that. Yes. Every record says, and she is the widow. After a death of a person in the breadwinner, post, small, they're not asking for your general manager's post. He was only, what was he?
Messenger.
Messenger. To him, if you trouble like this, why not we allow this appeal with the cost of rupees 5 lakhs?
Millard, the Lordship may give him time.
20 years.
Millard, actually he has not applied in the 2005.
That is not the ground.
Millard, that
your ground is there is a rival. You have a auntie.
Another
you have a auntie, therefore we cannot.
Millard, that is another ground also. He has not applied in the time after 10 years, 9 years. He has applied.
Anyway, you said you wanted somebody to be the wife of that deceased man. Perhaps he will shiver in his grave. He will shiver in the grave because he says, I have married only this lady. Bank is saying that I have married another lady. All your records show. No, we will not allow like that. In compassionate appointment, I do not know what has happened in your state. 20-year-old now. He died on 30 January 20. We'll take up this matter. 31-year-old. On 30th, if we have this matter, it will be 21-year-old matter.
It is. That is what is the application. So two grounds is first is what I have said. Second ground is it is applied application was made.
That gives an impression. Somehow you wanted to reject the application.
No, Millard, that is not the case. That not to reject the application.
Brother, how can
then what's the answer?
your record say that lady is the wife? You want to set up another lady as the wife?
No, Millard. That is not the case. Case is because of his son has the lady's son has come and made a claim saying that I am also the son of the deceased.
Any other point? You want to say anything on the cost?
Millard? No, Millard. I want just instruction. What instruction only to see whether ex gratia payment is to be made or not at that time, whether 2014.
No, you have said the ex gratia you apply for. You are saying made to be given or not that?
No, that is not given. What I am saying that date has been given 30th September 2014. Till then, if you apply, then ex gratia will be considered. That has been stated in the letter annexed that 3rd June 2014. So your lordship may give 2 days time so that I can.
Where from? Bank from which place?
From Bhubaneswar, I will take call in
tomorrow. We cannot see how much time we have wasted today.
Tomorrow.
Go any good cases.
Millard, tomorrow definitely I will come.
Tomorrow.
Millard.
Tomorrow you have to bring on what basis you assumed.
Millard.
That lady is the widow.
Millard. I will clarify.
Number 2, how much money as ex gratia is payable?
Millard. That I also.
And what would be the amount at the rate of 18% interest on that money? That calculator also you have to bring it. We don't have calculator here.
Millard. I will definitely.
Yes. Tomorrow.
Millard.
Perhaps you people have taken the family of the bereaved families for granted. No court is going to do anything.
No, Millard.
Our panel advocate is like Palkiwala. He will save us.
No, Millard. That is not
the impression.
With my lord's permission, may I say sentence? After the order of civil imprisonment, they discharge all these entitlements. The money.
That they are given.
Till no. We have to file one execution petition.
You give all that. You give entire material in a memo. We'll take up that. Then it will be not 5 lakhs. Yes. Tomorrow.
Item 26.
How they harass people. For civil imprisonment, only after civil detention is ordered, money has come to their hands. Till then, what that lady should do with the 3 children? No heart at all.
Yes.
Yes.
In item number 26.
26.
On behalf of the respondent, only thing. Only thing I want to take your lordships 1 minute with your lordship's permission.
Yes, sir.
That
if this writ appeal will be maintainable against an order passed under Article 227 by the Honorable Single Judge, then your Lordship, I will request your Lordship to hear both the sides. On the point of maintainability, the law has already been settled by Honorable Apex Court, as your Lordship knows.
Apex Court said,
and also
in Ridge Hotels.
Again, no, other case also by our...
From your state.
Again.
From your state.
Again. No, that has not been reversed. That has not happened.
Therefore, it is...
By our honorable full bench.
They have held like that.
Held. Because earlier in 2006, the writ appeal was maintainable against an order passed under special statute. Thereafter, the Honorable Division Bench referred this matter to the larger bench. The larger bench, they decided in item number 234, where there is an order passed by the London Single Judge under Article 227 in a special statute, no writ appeal lies. So here is a case. Same case, because the last page, in other 10 cases, I have lost those 10 appeals, because in which I was for the appellant. And also,
what do you say, brother?
You have to go to the Apex Court.
The full bench has said, if it is a 227 order.
In my difficulty, on behalf of Mr. Lenka, due to urgent...
Mr. Lenka is government educated.
No. He was here before lunch, but some other day you were.
Tomorrow.
The sole question to be decided by
maintainability. This is the position. So many things have to go. But kindly see appealability, intra-court appeal. Intra-court appeal, there is one judgment to which in fact, I was the author of the judgment.
In that full bench, in full bench case,
Try to understand what sir is saying. No, that we are coming to you. It is going to help you. What I am going to say. One bench, Dharwad bench in Dharwad, Karnataka High Court, Dharwad bench, identical question arose based upon Karnataka High Court Act 1961. We held intra-court appeal is maintainable. That is stayed by the Apex Court. That if you bring, that may add this one. But anyway, everything is discussed by the division bench, full bench itself now.
37 cases they have taken refer to while deciding that principle. The ratio that has been decided by taking recourse to all those decisions. Because the division bench deferred. And it was a refer to the larger bench. This is the decision. This is not maintainable. What to speak of?
Give me the reference.
Again?
Reference study.
Mr. G, 2008 2 OLR FB 725.
That's the power. Thereafter, I have got other 3 cases also.
Let us.
Sufficient, no blind.
That he pays to be. We'll give short period, we will give him.
Because it will take 1 second to your lordship. I know your...
Yes, sir. Yes, sir. Tomorrow? Tomorrow? Tomorrow.
Item 27?
Right. Tomorrow.
May I request your lordship
the issue of maintainability of intra-court appeal.
Okay. At the top of the list, may I request your lordship?
Let it come. We want to see you sitting in the court hall. We get inspiration from your smile.
That is, I would like to watch.
We'll do that. We'll get tomorrow, all right?
Tomorrow?
Yes.
Item 27?
Item 27, there are 2 writ appeals mirrors. Writ appeal 965 and 966 mirrors, 25 mirrors.
Yes.
These 2 writ appeals by order dated 23/6/2025, a coordinated bench of this Honorable Court mirror by region order admitted both the appeals mirrors. And thereafter mirrors on 11/7/25, this Honorable Court mirrors also by a direction directed the petitioner mirrors to apparent minors to file certain documents. Those are also complied with by application dated 4/3/2025 minutes. Sorry, 21/7/2025. Before the matter, open up minutes, I have a humble submission of lordship minutes. It's the last I met an accident minutes. Because otherwise I would not, normally I don't appear on VC.
You want some other day?
He wants me that I am not fixing to because my medical accident. But I am petitioner.
You are
the petitioner borrower. Despite having the judgment in my favor, despite there is no stay, despite all my 4 properties are mortgaged by with the bank, I am unable to operate my account even for 1 rupee, my lord.
Anyway,
14 crore.
Sir, which date you will be all right to argue the matter? Which date you want us to adjourn?
I will pray for at least 1 week time because I have MRI today. So
we will give you 1 week. Next date, kindly do not ask for adjournment so that your friend.
Normally I never do, Willows. Your lordship can kindly.
On Tuesday.
3rd of February.
3rd of February, all right. No, 3rd or 4th, we have many matters. We cannot reach. 5th February.
5th February.
5th February. 5th February, yes.
Any other date you want?
Guruvar. That's first day we have little problem, Millards. Either Friday or Millards on 7th or Monday, Millards. Either Friday or Monday, Millards. I think 8th will do. 9th.
Sunday.
9th.
9th we will have that. On 9th, kindly be ready. Because he is saying he cannot operate his bank account itself.
Well, for last 2 months, they zeroed down my DP limit.
They have not come up also with the application.
So,
anyway, those are
able to operate for 1 rupee also. My machine, my manpower, everything
I
is.
understand you have not making application also for renewal.
Well, I
reminder. Anyway.
Request of learned counsel appearing form. Yes. Yes, sir. Quite well soon. Yeah. Is secretary has come now?
Yes, sir.
Please come, sir. Come here, come this sir. What's your name, sir?
Sir, Vijay Kumar Khandai.
Vijay Kumar Khandai. Right. Khandai. Right. Who were predecessors? You were earlier people. 2018 August 2. When that letter of appointment, the recruitment the letter was sent, na? By the secretary.
Yes, sir.
On which date it was sent?
Because all of that happened in 2018.
2018?
Yes, ma'am.
Who were the secretaries in 2018?
Sir, Kumuda Chandra Malik.
Kumuda Chandra Malik. My friend, write down. In which department presently he is working?
Sir, he is retired.
Now retired. When he retired?
Sir, 2022.
21 months. I was just checking on Google. I found his date of birth.
21.
21.
So 4 years are over now.
Yes, ma'am.
What's the limitation period for disciplinary inquiry against Mr. Fonti?
4 years.
4 years. He is saved by time.
He is retired on 28th of February 2021 must be the retirement date.
4 years from the date of cause of action.
From the date of cause of action, it is. Does he any information where he is residing, etc.?
Right. I will provide it to
Possible.
Because the state will be able to better because they maintain
He's
the
taking pension, no?
pension
He's
paper
not
orders.
permitted this.
After hearing a very lengthy and passionate submissions at the bar, come on, we are noticing several lacunae in the recruitment process that began way back in the year 2018. First of all, one such grave lacuna is as to
hasty forwarding of first final select list to the government for issuance of recruitment appointment orders, which eventually came to be issued. When the division bench, accorded bench of this court in August 2018 had directed, is it August 2018?
6/8/2018.
6/8/2018 had directed for furnishing the key answers of the examination held in connection with the subject recruitment process. First up, it hardly needs to be stated that the key answers are given to the candidate who have staked their claim for recruitment to make self-assessment of their performance in the examinations and thereafter to make a representation against placement or non-placement of their names in the select list. Based upon such a self-assessment, next paragraph. Though learned panel counsel appearing for the appellant OPSC very passionately argued the matter, seeking invalidation of a learned single judge's order impugned herein, he is not in a position to tell us why the final select list, first final select list was forwarded to the government when something had to be undertaken at the hands of OPSC in the light of 6/8/2008 order of the coordinate bench. First up, the present secretary Shri Khandatre, on request hastily appearing before us, assisted the court. First of all, only write so much, otherwise he may mistake him that he has given the name. In the above circumstances, assisted us. First off, he tells that he was not the incumbent of the office of Secretary OPSC during the relevant period. First off, on some inquiry, we learned that one Mr. Kumudha Chandra Malik was the secretary during the relevant period, and therefore he needs to be called to the court to answer certain doubts, clear certain doubts that have arisen in the mind of the court. First off, we are told that he too has retired way back on in
February 2021.
In February 2021. First off, be that as it will. First off, his presence before us would facilitate a due adjudication of the list at our hand. First off, next paragraph. In the above circumstances, we direct the registry to send a police notice by way of emergent notice to Mr. So-and-so to appear before the court on 10/2/2026. First off, police to search that person and serve the notice without saying without putting forth any excuse
any excuse. First off, non-service would be viewed very seriously, and disciplinary action may be ordered against the erring officials from the police department. Yes.
One month, can it be on 16th?
16th. But by that time, our memory may fade. Now our memory is fresh.
Well, it's on 8th.
Yeah, 8th. 8th is Sunday, unless you procure some order at time.
9th.
9th.
Yes, well.
9th. Okay, let him come. Will not leave that way. Officers are answerable, accountable. Otherwise, all substandard people gain entry.
Let him cooperate with the address bracket. It will be convenient for the police authority, if at all. So, because service book is there.
The present secretary, Mr. So and so.
Let's let the state do it. The state should, because state is the they have the custody of pension.
The state government shall furnish all service particulars from the pension records, from the present record to the jurisdictional police immediately. Yes. Urgency.
I am deprived of getting electricity from 2024 being the landowner. That matter.
That because of dues and other things which you argued other day. Yeah. Urgency.
Conceded through no confidence motion, that matter went to the larger bench.
My lord has taken a decision that is also but 24(2)C, my lord, that no confidence motion of the Sarpanch.
He has been unseated. So
what is the urgency? All farmers will till the land, laborers will work in the factory with all these petitions. What are you going to do?
As the present secretary maybe
next week, man.
As the personal
next
item 32, the last item.
One line we should write. The assistance, presence and assistance of the secretary of OPSC, Mr. So and so, is appreciated. Registry to share a copy of this order with you.
Item 32, the last item. Matter of 2010, that is the regarding regularization. I don't have an objection, but also fix a date and time it will be fixed.
On 12th of February, we take that.
Can it be at 3 o'clock?
No, nothing like that. We are against that proposal. Yes. Yeah.